it comes up, then please mention.
My
From
lady,
now,
I'm so sorry. The
no,
2087.
let it appear first, then we'll see.
My lady, in 2087.
So you want inclusion?
Disability.
No.
My lord, the petitioner is for family pension. The petitioner.
What you want?
The petitioner is
What you want?
in order to get family pension.
No, where is the matter?
The matter is his husband is gone forever.
Where is the writ petition now?
The writ petition
Out
is
of the list.
huh?
Out of the list.
Out of the list.
Do not mention any.
Out of the list. It is not in monthly.
Sir, do not mention. Can you hear? Do not mention any matter for inclusion. Yes.
Now,
Do not mention. Yes.
to say what the petitioner can do.
Upon notice to the state, may I mention one matter for upgradation? This is a CPF to GPF area pension from the date of retirement to the date of refund.
Give. Serve notice upon your other side. Yes.
My lordship, there is a
My lord, what the petitioner can
correction
do.
of the order. The typing mistake in the order regarding the date of the order.
Petitioner can do, my lord.
Lordship, may I permitted to mentioning this matter for restoration, Lordship.
Yes.
Restoration,
He's over 80.
You want inclusion in the man?
Lordship.
Do not mention, please.
Which your petition is entitled after obtaining a PhD degree, and now it's pertaining to 2022. Not a single hearing has taken place, and your petition is about to retire this year, Lordship.
Yes.
And only praying for upgradation. The matter is running in the monthly docket number 830, Lordship. Is about to retire this year.
Doesn't matter. Let him retire. You cannot prepone or postpone somebody's date of retirement, isn't it?
Definitely.
So,
I'm
when
praying
did you file the matter?
2022, Lordship.
Right. And from 22, you permitted the writ petition to remain pending for 4 years nearly.
Lordship, it was mentioned.
Then, and now when he's going to retire, you come up and see what to be done.
Lordship, may I mention next week once again, Lordship?
Please do.
My lord.
My lord.
Lordship, for correction of the order to be mentioned. For correction. That was-
My lord, restoration, my lord.
The restoration application.
No inclusions, please. Yes.
My lord, I'm seeking leave, my lord, for a modification application, my lord. This purpose of seeking leave, my lord, the main matter, my lord, has directed to appear on 10th of December, which is a Wednesday. My lord, if leave is granted, so that it is tagged with the.
Modification of what?
So there was a direction passed by the court, my lord, to publish all the OMR sheets of all the candidates of the second SLST, my lord. There are certain aspects, my lord, we want to bring it to the notice of.
Very well.
My lord.
Is it in connection? That matter is due to appear.
10th of December.
Very well. এটা ওর সাথে tag করে দেবেন.
My lord.
Is it affirmed?
No, it is not affirmed, my lord.
Get it affirmed, then come.
My lord, I'm mentioning for new motion. My petitioner is
I do not want to know the merits of the matter. Is the matter there in the list?
yes, ma'am.
What do you want now? Upgradation?
No, ma'am. It is in the list in Friday. Item number 139.
Right. So you want to be taken up?
Yes,
So you
ma'am.
want upgradation? Come
Yes.
next week.
My lord.
All right.
My lord. My prayer is also.
Family pension ke CPF to GPF.
It's there in the list.
No, my lord.
Don't mention.
My lord, mine is also
My
for
lord,
inclusion, my lord, but I have
my
some
lord,
urgency, my
for
lord. If my lord
inclusion.
allows me, I'll place the urgency, my lord. It's for inclusion.
No, don't mention, please.
My lordship, may I permit to mention one
Is
motion?
somebody senior to you standing?
For upgradation, my lord.
Please excuse. Yes.
May I mention one
Next week.
motion matter? It's in a monthly list, December, item number 1145. I want upgradation, ma'am.
No, sorry. Yes.
My lord, it is kind of inclusion. My lord, this matter is a bit urgent. My lord, I have mentioned this matter earlier.
Yes. What is urgency?
My lord, the petitioner is a widow and her husband died in 2023, and for 2 years, no death benefit has released, and the petitioner is really starving. My lord, I have mentioned this matter earlier. My lord, kindly take
When did you mention?
before last week.
Before last week? If you have mentioned, then do not repeat the mentioning. Steps are being taken to get hold of the file, and as and when the file is available, it will be listed. So do not mention.
Lordship, this is a question and some.
Yes.
Lordship, this is a matter regarding to 11 to 19 and 11 to. Lordship, wrong question and given marks to the all candidates. Lordship, the similar matter, your Lordship fixed on Thursday. Lordship.
Yes. All right. Is it there in the list?
This matter was appeared last Friday, but then matter has been gone to the January. Your Lordship.
All right.
Indicate the
All right.
similar-
Give. Serve notice upon the other side. Yes.
I know this matter was previously mentioned. It's in relation to the previous marks allotted on previous teaching experience, my lord. It is listed as item 52 today. If some preference could be given, if it could be heard early.
Let the main matter be heard. Whatever order is passed will cover you. So no use mentioning and upgrading it. All right.
My lord, my lord, this is a second round of litigation, my lord.
I understand. Please wait. Yes, call the list, please. 1997. All right.
Can to I appear my name maybe.
The name is not there.
No, Mr. Subir Shanal is his name may be deleted. He is not appearing in Can 2.
Oh,
Wrongly, my lord, it has been.
wrongly. That name will go out.
Yes.
4 names are there.
Entire names would be go out.
Oh, the entire set will go out. All right, give.
This is nothing else.
Matter has appeared in the list for correction of the order dated 1st December 2025. Stop. The names of the appearing councils in respect of Can 2 of 2025 were wrongly recorded. Stop. Be it recorded that take down the names such and such persons appears on behalf of the applicant in Can 2. Let this order be read along with the other order. And the order dated 1st December 2025 stands corrected. Rest of the order remains unaltered.
Grateful to your lordship.
Yeah. Slipped an in. 2.
This is at my instance, my lord. Here in this matter, the entire list names of the SSC advocates were missing.
Missing. Give.
My lord, I am just providing.
Yes. Same thing. Their names were not recorded. Agetta inadvertently recorded. It are not recorded. Yes, sir. Yes.
In paragraph 4, my lord, in this order, it has been written that the petitioner passed the written examination in ongoing selection process.
Paragraph 2.
Paragraph 4.
4. Huh.
But it is that because we have been categorized as general, my lord, we have been not called for the verification, document verification.
But then written examination cutoff marks did you achieve?
Well, cutoff marks for the reserve category is 36. But we have been considered as general. That is why we were not got for interview. We called for verification.
Order copy to the you order a copy in it.
So your name has not been published in the interview list.
Lordship kindly takes a page number.
No, tell me your name has not been published in the interview list.
Interview list has not yet been published. We are not called for document verification. The list for document verification.
But then it is only from the interview list that the document verification is being done.
Lord, it can be taken that way that Lord, but here it has been written that written examination in the ongoing selection process and her name has been published in the preliminary.
No, your name has not been published. That is the thing.
What page?
এটা আলাদা করে দেওয়া হয়েছিল জজকে মামলা শোনা হচ্ছিল ওটা আলাদা করে দেওয়া হয়েছিল
Matter has been mentioned for correction.
Malad,
The order dated 3rd December 2025. Yes, please.
I'm late by
Malad, in this matter, in
Yes.
the application form, he has not disclosed anything.
But this is for correction.
This has come for correction. One
Okay.
line is
All right. All right.
order has already been passed on 3rd of December. Is the writ pending? No, the writ has been disposed of also.
Yes, yes. All right.
Matter has appeared in the list for correction of the order dated 3rd December 2025. Stop. Learned advocate for the petitioner submits that the submission in paragraph 4 of the writ petition, submission of the petitioner has been incorrectly recorded.
You know.
Stop. In paragraph 4, the word, paragraph 4 first line, the word past, PASSED, shall be replaced by the word appeared, and a not will be added, NOT not will be added in the second line of paragraph 4 between has and been, has not been published. All right. Rest of the order remains unaltered. The order dated such and such is corrected accordingly.
Grateful.
Yes, next.
Obliged.
Four.
Malad, I am appearing on behalf
Item
of the...
4.
Oh, sorry.
Malad, I am for the school authority, Malad. On the last occasion, Mr. Roy Malad took time.
অনিমেষ বাবু, এটা 3 এর ফাইল, 4 এর ফাইলটা দিন। Yes.
Malad, today I am also Malad handicapped because of the Malad no objection Vokalatnama has not received by me from Mr. Sunit Kumar. On the last occasion, your lordship adjourned it for 1 week. Malad, I am praying Malad only after 16th Malad may it be taken up. It will be settled between us. Malad.
What is settled between us means?
Malad, Mr. Roy and the school authority, Malad.
That is between the school, but the
Yes,
petitioner is suffering.
Malad,
What
that
is your prayer?
Malad, prayer is, Malad, they have alleged unauthorized absence have been taken at resignation.
All right.
Then that can be permitted. First, Malad.
All right. So we can adjourn it because there is a prayer.
Do that, your lordship. Do that, your lordship.
All right.
You can't. Malad, would your lordship take it up on 21st?
Virus of the rule also challenged him.
I am not placing the virus.
21st, immediately prior. 21st is a Sunday.
Oh, sorry, Malad. Any after 19th, any day convenient to losses. But before Malad vacation, if
Why? What is so urgent that it has to be heard before the vacation?
if I place it for 5 minutes, your losses will
Then
understand.
place it in the next year. Let him also take instruction in the meantime.
And because of this, Malad, appeal has been adjourned in another matter. That's
What can the court do? The matter is there in the list. It's taken up. Request from the council. What
no,
to
no,
do?
I
22nd Malad made.
22nd.
Do that, your lord. Let
Please
us
come.
try, your lordships.
Learned advocate representing the
School authority, Malad.
school seeks accommodation. The prayer has been made to post the matter on 22nd December. Stop. List on 22nd.
নামগুলো দিন।
Yes.
আপনি ওখানে অ্যান্সার দিন, আমি এখানে তো করবো। আপনি
appealing for the commission bill.
Yes.
আপনি ওখানে বলে যান।
Probably my learned friend will take some time. I'm coming back, your lordship.
Because we both are in the same matter.
Item number 14, I have to give short reply.
No, which one is yours?
5.
This one.
You are
or
not
you
the
can take it
applicant.
up on Wednesday. Applicant.
Applicant.
Let's I start, my lord. Thereafter,
Let
my
it
lord,
start.
because I have. My lord, we remember the EWS matter. The point, simple point involved there here in my lord, that whether the last date, that is 21st September, that the last cut-off date will be applicable for EWS certificate or not. That's the law point.
Yes.
That the last cut-off date, that is 21st September 2025, in pursuance of the advertisement published by the West Bengal Central School Service Commission, that would be applicable for EWS certificate or not. That is the subject matter in this writ petition, my lord. My lord, I want to hand it over the whole bunch of the certificate, EWS certificate, because the although certificate is annexed, the government status.
Yes.
This shows the status of the certificate. Well, the last column, kindly see. Just one. Certificate valid from 2025-4/1. That means 1st April 2025 to
31st of March 26.
So EWS certificate, economically weaker section certificate, is valid for 1 year. Whenever any advertisement floated, they, in pursuance of that advertisement, they applied for getting the assets declaration. Thereafter, their verification, they got the certificate. Malad will remember on the last occasion, kindly turn page number 128. I, Malad, made a chart. When they applied,
yes,
when they applied, page number 128 onwards, when they applied for EWS certificate and when they got it, I made a chart. Kindly turn page number 127.
What does the advertisement say? When is the date?
Last date. I will place the advertisement, the respective
Right,
rules.
127.
Yes, 127. Kindly see well the particulars.
Yes.
Time limit prescribed as per the Public Service Guarantee Act, that is 28 days. So 28 days is the maximum days. Beyond that day, they issued the EWS certificate. Now, my lord, kindly take the rule, because I believe my learned senior friend, my lord, they will place the rules, and what they did, my lord, I place thereafter, my lord. Kindly take rule 2R, 21R, page number 120, sorry, only 24.
Yes.
Reserve category means a category of reservation in respect of scheduled caste, scheduled tribes, other backward classes, and physically handicapped candidates, and other categories of reservation, if any, enforced by an order of competent authority as at the last date of receiving of online application, as may be notified pursuant to advertisement to be issued hereunder. Nowhere it is stated EWS. Now, my lord, kindly take the schedule 1, page number 31. Page number 31.
Yes.
Well, got it? The age limit column,
Yes.
the nota bina portion.
Yes.
The second nota bina portion, that is for consideration of application in SC, ST, OBC, PH. Got it, my lord?
Yes.
Categories. There is no mentioning about EWS categories. Certificate issued by the competent authority of only the government of West Bengal as on or before the last date of receiving online application shall be treated as valid document. There is no such mentioning of EWS, because they know it very well. EWS certificate validity for a one particular financial year, because this all about asset declaration. I will place that rule later on, my lord. candidate belonging to such category from other state will have to appear as a general candidate only without any corresponding concession, relaxation in respect of age, fees, and qualifying marks. So, there is no such mentioning of EWS category. They ought to gather the certificate within the last stipulated date. That too, only this rule applicable only for SC, ST, OBC, and PH. But what West Bengal Central School Service Commission conduct? But I placed one after another, my lord, notification. What they did actually did. Notification gulo porpor bolo. Now, yes, madam. Now kindly turn, my lord, page number 165 onwards notification. What they did, they themselves violate the rule.
Yes.
Kindly turn page number 165 onwards.
165.
The notice.
Yes.
The last, admittedly, the last cutoff, just before that, my lord, the last cutoff date, I just show it from the advertisement, although that is extended for 7 days. My lord, kindly turn page number 38. Before that, my lord, what was the last closing date of online application? Page number 38. Can one annex 21 can one closing date, my lord. Got it, my lord? The scheduled date, page number 38.
Yes, yes.
Closing date 14 July 2025. Later on, by a notification, they extended 21st July 2025. My lord, that notification is not annexed, I believe.
All right, then.
So, my lord, kindly thereafter kindly turn page number 165. So, last cutoff date is 21st July 2025. Whosoever declared themselves within that stipulated period in that 4 category, SC, ST, OBC, and PH, whosoever declared themselves, whosoever got themselves, they only considered SC, ST, OBC, or PH, no other candidate. Now, my lord, kindly see the advertisement, their notification. Addendum notice regarding edit option. This is to notify all concerned in connection with second SLST 2025 for classes 9, 10, and 11, 12 that in view of order dated 28 July 2025, the Honorable Supreme Court in SLP Civil number 17422 of 2025, State of West Bengal versus Purabi Das and others. I will place that order, ballot. There is no such mentioning. You will extended that date beyond the last closing date. And other connected matter, the online portal will be opened for collection of category details from 5th August 2025 to 11th August 2025. They extend themselves, they extend the date by violating their own rules. The candidate, I could say, violating the state government rules because that rule is framed by the state government. They are the mere statutory body, so they can't violate it. But they violated through this notice. The candidate will have to first log in and choose the edit option. Then he or she will have to select the category from drop-down menu. The candidate will also have to specify the subcategory, the applicable certificate number, and issuing authority in separate text boxes to be made available after category is chosen from drop-down if applicable. Any final decision will be subject to outcome of pending legal proceedings. Now, very next notice, that is page number 166. Very important, my lord. That is most important notice. In continuation, that is dated 5th August 2025. In continuation of our earlier notice issued vide memo number such and such, that the earlier notice dated. This is to further notify for information to all concerned that all candidates, irrespective of their category, are required to mention their specific category within bracket. That is most important. Caste, class, EWS, PH. So they treated all this in same categories because that is the rule. That is the governmental notification. I will place later on. In respect of place in their application form through the edit option provided in the website from 5th August 2025 to 12th August 2025. So they enlarge the date by giving this edit option to throughout all categories. This is the first time because in first notification, I inquired it. First notification, there was two options. One was that SC, ST, and PH, and for others, whosoever, general, OBC, EWS, there was others category. They not mentioned general or unreserved or EWS. In the first round, up to 21st July 2025, every candidate, either they mentioned SC or ST or PH or all others. So there four category was there. Later on, by dint of this notification, they again, all the candidates who are in other category, they categorize themselves in three categories. One is unreserved, another one is EWS, another one is OBC. But because of that OBC matter is going on, so my lord said later on, after last closing date of application, they themselves declared whosoever, even can one applicant also, in the first round when they fill up their form, they fill up their form by mentioning others. Later on, they by edit option, they fill up their forms as EWS because they're not annexed their first round online application. Now, my lord, very next, and one thing, my lord, through this notice, it is clear that caste, class, EWS, and PH, they similarly treated. It is evident from this notice. Now, my lord, very next notification. The exam conducted, the 9-10 category exam conducted on 7th September and 11-12, 14th September. After completion of the examination, they again issued another notice on 22nd September 2025.
Yes.
This is to notify all concerned that though opportunity for updating stroke editing caste category. So caste category means SC, ST, OBC, EWS, PH, then ETC, Ejusdam generis. That means any others categories have been offered to the candidates several times. A number of candidates have not yet updated their categories in their application forms. Therefore, a last opportunity is being given to the candidate to update the same in their application for second SLST within bracket 80-2025 for classes 9, 10, 11, 12 from 22nd September 2025 to 26th September 2025. So, after examination, by violating the rule, they give opportunity to all caste category, 7 except EWS. The candidate will have to first log in and
No, it's all right then.
so
Then-
that is the rule. So last
Yes.
all the candidates hearing, all the petitioner hearing, they gathered their EWS certificate before that last cut-off date, 26 September 2025. All
So
the
they did not edit.
they not give the opportunity. That's my case. They give opportunity by this notice to only the OBC candidate, no other candidate. That's my case. And they says, kindly see the last order, my last order, 10-11-2025 order, para 8. In my lord's order, para 8. However, this bench has not been made aware of any order passed by the Honorable Supreme Court with regard to direction issued in respect of SC, ST, OBC category, extending the time limit for submission of candidates. Let the order passed by the Honorable Supreme Court or any other court be placed before this bench on the returnable date. This says, due to Supreme Court order, they extend that day only for the OBC candidate, no other candidates. My lord, and my lord, today I believe they appraise this court by that order, whether Supreme Court says beyond after examination, violating the rule. Now, my lord, I just want to place, my lord, to judgment, my lord, which supported my contention. Even if I got EWS certificate before verification, ought to treat me as a EWS candidate. Although I get all the Haryana division, Haryana division. তারপর সুপ্রিম কোর্ট এখানে আমি বোধ দিচ্ছি কপি Haryana Staff Selection Commission, my lord, by quoting that, my lord, Doli Chanda, my lord, will have the fact, my lord, and Ram Kumar Girija quoting, my lord, may I place that, my lord? But because this is a division, ultimate, that went up to the Supreme Court and Supreme Court upheld it.
Does this matter relate to EWS?
EWS, my lord.
Show me which portion.
My lord, kindly the first, my lord. So they denoted it as a special backward classes. My lord, this letter patent appeal is, my lord, last paragraph, that while making the said application, respondent number has claimed reservation under special backward classes category, though he also claimed eligible under economically backward person in general caste, EBPGC category. Respondent number 1 is called for scrutiny of document to be held on 29th August 2018. At that time, he produced EBPGC certificate issued by the welfare of scheduled caste and backward classes department on such and such, on the ground that the advertisement contained a condition that the said certificate should also have been issued prior to the last date of submission of online application form, that is 12/10/2015. The respondent number was not given the appointment letter, so they ought to place it before the last date. That's the factual matrix, my lord. Respondent number 1, therefore, my lord, I just skip it, my lord, that it is mentioned in the same fact, on the same fact, my lord, by quoting that. I just want to, my lord, emphasis supplied. My lord, page number 6. At Dali Chanda, my lord, I place the Dali Chanda and Girija also. The general rule is that while applying for any course of study or a post, a person must possess the eligibility qualification on the last date fixed for such purpose, either in the admission brochure or in application form, as the case may be, unless there is an express provision to the contrary. There can be no relaxation in this regard. That is the matter of holding the requisite eligibility qualification by the date fixed. This has to be established by producing the necessary certificate, degree, or mark sheet. Similarly, in order to avail of the benefit of reservation or weightage etc, necessary certificate have to produce. These are documents in the nature of proof of holding of particular qualification or percentage of marks secured or entitlement for a benefit of reservation. Depending upon the facts of case, there can be some relaxation in the matter of submission of proof. It will not be proper to apply any rigid principle as it pertains to domain of procedure, because I applied for the certificate much before the last cut-off date. Every infraction of the rule relating to submission of proof need not necessarily result in rejection of candidature. So Dali Chanda, I produce the Dali Chanda as well as the Ram Kumar Girija also. Ram Kumar Girija also quoted here in page number 4, my lord. Ram Kumar Girija also an ultimate. The court hold, my lord, page 9 onwards. The said judgment does not apply in the instant case because of the instant case. The time of advertisement, respondent number 1 could not claim under both SBC category and EPBGC category claim reservation under SBC category because it was necessary for him to seek reservation in the BPGC category as well. But without his knowledge and behind his back, the appellant has decided not to give reservation under SBC category. In this circumstance, the appellant cannot also contend that respondent cannot seek reservation under EBPGC category, although they got this certificate much after the last cut-off date. This is thus no necessity to doubt the genuineness of the same because it would have been issued after verification process by the competent authority. In fact, according to the respondent, the district administration was not issuing EBPGC certificate to eligible candidates who come back from SBC to EBGC category. That means that in our state, that is EWS category. And the district administration had started to receive the application for issuance of EBPGC certificate only when instructions were issued on such and such date by Chief Secretary, Government of Haryana, and only thereafter the respondent was issued in such certificate. So the respondent number 1 cannot be blamed for not claiming reservation or not producing certificate under the said categories such and such date. He could not have complied with the requirement because it would have been impossible for him to do so. The decision in such and such is with regard to determination of age of the candidate for selection by fixing a specific date of time. Thus, it was case of possessing a necessary eligibility condition, but not a case where a claim of reservation is made. As pointed out for the letter, proof of reservation claim can be submitted later. The decision of Ms. Rekha Chaturved is also one applicable of possession of essential qualification by a cut-off date and is not a case dealing with a claim for reservation like the instant case. The decision cited by the council for the appellant are thus distinguishable because this qualification for holding a post is certainly to be decided on the basis of the cut-off date fixed in the admission, but for availing benefit of reservation. Production of certificate issued before the cut-off date is not necessary, and there is no such rigid principle as held in Dolly Chanda versus Chairman J. Ispra. So, in the peculiar facts and circumstances of the case, we are of the opinion that no case is made out for interference with the judgment of the learned single judge. Accordingly, the appeal is dismissed. So, my lord, no rigid principle ought to applicable. Because of that, my lord, we applied much prior to the last cut-off date. The lacuna of the Article 12 authority, we got it, that too within the last cut-off date, that is 26 September 2025. They not allowed us. This case, my lord, went up to Supreme Court. Now, my lord, Supreme Court also upheld. Supreme Court are একটা copy though.
Yes, it is here. Supreme Court.
Oh, sorry, my lord. And that is our ultimate, my lord. I have not placed it the whole portion. Maybe. The appellant Haryana State Selection Commission published an advertisement on such and such date, inviting application for the post of PGT. The closing date for submission of online application was 21st September 2015. The last date for deposit of fee by the candidate was 24th September 2000. The advertisement itself specifies the post reserved for the various category, including SBC, special backward class, and EBPGC, that is equivalent to EWS 5%. The first respondent specifically applied under the SBC category for the post of PGT in political science. It appears that on 29th August 2018, the first respondent was informed that he was qualified in the written test and therefore he was called for scrutiny of document. In the result declared on 17 September 2018, the first respondent was shown in the general category. The first respondent secured total 118 marks. The cutoff in the general category was 120 marks, and therefore the first respondent was not selected. It appears that government of Haryana issued communication dated 21st February 2018 and 1st June 2018, recording therein that in view of the order passed by the High Court in such and such, the notification dated such and such should not be given effect. The said notification dated 27 September 2030 was for providing a quota to the candidate belonging to the SBC category. On 5th June 2017, a certificate was issued to the first respondent according to belonging to the EBPGC
Yes, I have
category.
followed.
So, my lord, that is the factual matrix, my lord. Thereafter, para 10 onwards, my lord, I just skip it, my lord, because of that it is mentioned, my lord. Following that, Dali Chanda and Ramkumar Girija, my lord, I just for my lord 2016 for SCC Ramkumar Girija. I just place that. I just 4 paragraph. Ramkumar Girija, 2016 2005 9. My lord.
That is regarding the caste certificate.
Yes,
this
madam.
Is the caste. Do not give the caste one. It is only EWS.
But that principle and analogy was taken.
Yes,
Madam.
yes.
2005 9 SCC 779 para 7 and 2016 4 SCC 754 para 4 14 and 18.
But there is a little bit of difference between a
yes.
caste
Madam, no doubt about it. Because of that, madam, EWS certificate. I just, madam, summarize my submission that, madam, EWS category is a unique category, but because of that, this benefit wants to given within the unreserved category who are economically backward, and that to ascertain each financial year, my lord. And that's why, my lord, after floating the advertisement, they applied for that EWS category, although there is a stipulated time, but due to laches on the part of the Article 12 authority, my lord, I got this EWS certificate after last cut-off date, which is mentioned in the advertisement, but before the last cut-off date, subsequently by the date of the notification, that
Very
is
well.
for 26 September.
Very well, very well.
That's my case, my lord.
All right,
It will be
yes.
kind enough if considered
Commission,
all the
please.
petitioner as
Yes.
a WS category.
My lord, kindly come to page first 44.
May I take my lord?
Yes.
Because,
Kindly
44.
come to page 44.
Yes.
But your lordships will find from there the category has been described as general.
Yes.
All are general category, they have made this application. C46 also.
At the time of floating the advertisement, was there any reservation for EWS?
Yes, yes, yes.
No.
The lordships will find from the advertisement. Advertisement page. Kindly come to page 37. At the bottom. But kindly just. It is 11.
Page 39, I can see.
Page 39, lordship has sent it.
Fees for the examination.
Fees
It
for the
mentions
89 rupees 50, a silka type PH.
and general and OBC. There is no EWS.
No, OBS, category has been, category one has to say, if he wants to get the benefit from the EWS, then EWS category has to be set.
Where is that category in your application? In the
Right.
advertisement?
Then they are not entitled to get it.
Show me from your advertisement.
If it is not in if the advertisement it is not there, then how they can get the EW category? We have made
Very well. Very well. In that case, your addendum notification.
Yes, that's right. My lord, I will, in that case, I will file also affidavit. My lord, kindly come to the note first, page 41. And there are so many candidates, those who have submitted their form in EWD categories. My lord, for consideration of belonging to reserved categories, the certificate issued by the competent authorities of only the government of West Bengal on or before the last date of receiving online applications shall be treated as valid documents. Well, that has been extended. But kindly come to page 165 first. This is to notify all concerned in CW2 second SLST class 9 and 10 that in view of the order so and so or in SLP so and other connected matters, the online portal will be open for collection of category details from 5th August 2025 to 11th August 25. The candidates will have to first log in and choose the edit option, then he shall have to select the category from the dropout. Now, next is kindly come to page 166. In continuation to earlier notice issued valid memo number so and so dated 30th July 2025, this is to further notify for input to all concerned that all candidates, irrespective of their category, are required to mention their specific category, caste, class, EWS, PH, etc. in the respective place in their application form through the edit option provided in the website from 5th August 25 to 12th August 25. And EW has been set up to 12th August 25. Next, my lord. Page 167. This is to notify that 22nd September 2000. This is to notify the all concerned, though opportunities for updating caste category have been offered in only this is a case of a caste category, not the other categories. Caste category have been offered to the candidates several times. A number of candidates have not yet updated their categories in their application form. Therefore, last opportunity is being given to the candidates to update the same in their applications. So and so. The candidates will have to first log in, choose the area. This way we will have to select so and so. In case of any candidate fails to update his category within 26 September 2025, the category of such candidate will be treated as general. Therefore, this is a caste category concern. It has been extended. So far, EWDs, it was not extended. It was not extended. EWD and PH. Now, this has not been done. Now, Miller, when they have given it, Miller, kindly see the page is certificate, kindly see. No. Miller, kindly come to page 48. This is on 18th September 2025, long after. Valid for the year 2025 to 2026. His status so-and-so, his photography that is so-and-so, the weaker section of his family is below to so-and-so for the financial year 2024. His family does not possess so-and-so. But this is dated on 18th September. Next one, kindly see 55. That is also Millard 18th September. All are after that. Therefore, Millard, this is not in terms of Millard. Just kindly give me 1 minute time, Millard. Rules to work on reservation. These are other category sessions. Now, Millard, kindly come to rules, page 32. There will NB there for consideration of application in SC, ST, OBC, PH categories. Certificate issued by the competent authority of only the government of West Bengal as on before the last date of receiving online application should be treated as valid documents. Candidates belong to such categories from their states will have to appear as general candidates only without any so-and-so. This is the reservation clause I have shown to you. Now my submission first would be that these certificates were not given within the time specified, long after. And your lordship, I will show to your lordship, your lordship's order, your lordship has dismissed the writ petition on that ground also. But the judgment which has been cited to your lordship, that Rajasthan judgment system, Rajasthan, Punjab, Haryana, the lordships will find interestingly, I don't know, nobody has noticed it in the Supreme Court. Application was filed in 2015 from the judgment of the EWS. My lord, this benefit has been given by constitutional amendment of 103 in 2019. EW was not entitled to get in 2015 at all. Nobody has argued that point. Nobody has brought this notice within the Supreme Court. This has been notified. I just give your lordship's date. The Constitution 103rd Amendment Act 2019 was given effect from 12th January 2019. Therefore, I don't know, Millard, I will submit that judgment was completely ignorance of the constitutional amendment. No one was entitled to get it. Now I come to your lordship, Millard, two judgments I will cite to you. This is the main factual thing in this matter. And if required, Millard, I will file also have an affidavit. And other CWUs have filed the, my lord, the application with their category of EWD. Now, my lord, how can I give it? But there is a form to one of my junior, if it is there, can you see the Supravar Manto? Do you have, Mr. Bhattacharya? Can you,
Yes.
can you see? There he has described himself as category EWS.
Later on. Later
But
on.
similarly, others have also filed EWS.
Later on. When?
Mr. Samim, I know you are more knowledgeable than me. Kindly allow me to speak.
No, sir, I am not saying.
No, you are. I am hearing you. When? How? I know you are the most tallest lawyer of the Calcutta High Court. Allow me. Now, let kindly see. These are the in the application form itself. An application fee, see, 500 rupees. It has been given. Now, my lord, I will cite two judgments, including the judgment with that both the 2009 and 16 has been considered. Kindly come to, my lord, the judgment. Kindly come to similar to 224 1 SCC page 448. That matters also relates to economic, kindly at the top, economic backwardness plus EWS categories. Kindly come to Miller paragraph 49. In Gaurav Singh's case, it has been categorically held that assets for the particular financial year prior to the year of submission go to the root of the eligibility of the candidate in the DW. It has been further held that the candidates whose INSCs are not in order did not have any legal right to be considered. It has also been held that no candidate can claim any legal right for reconsideration of the candidature by submitting a fresh certificate and or rectified certificate. There's a fundamental distinction, etc., etc. Then we'll kindly come to paragraph 51. It is also very well settled that if there are relevant rules which prescribe the date on which the eligibility should be possessed, those rules will prevail. In the absence of rules or any other date prescribed in the prospectus advertisement for determining the eligibility, there is a judicial chorus holding that it will be the last date for submission of the application. Here we have extended it. Now, kindly come to, paragraph 50. There is a fundamental distinction between Charles K. Sarid line of cases and the case at hand. As pointed out earlier, the eligibility for being categorized of EWS candidate crystallized only when the INSC is issued. And in this case, as required under the rule, it was to be issued and possessed by the candidates before 22nd September 2022. Now, kindly come to paragraph 58. In this case, rules clearly exist in the form of CSD. It has also been settled that determination of eligibility cannot be left uncertain till the final stage of the selection. Since that would be to uncertainty, further it is well settled that if rules prescribe the last date on which eligibility should be possessed, any relaxation would prejudice non-applicants who for want of possession of eligibility would not have applied. Then relaxation would then be selective, leading to discrimination. Then kindly come to paragraph 61. The strong reliance placed on Ram Kumar Gijoria and case also does not impress us. Not only was there no rule like we have in the present case, it was only while declaring the result, the requirement of submitting the OBC certificate before the cutoff date was introduced by the selection authority there. Moreover, unlike the present, there was no contention or issue raised. In that case, the eligibility ensures or crystallizes only on the issuance of the certificate and on possession of the certificate before the prescribed cutoff date. But this is the judgment, Miller. Another judgment, Miller, I will show to your lordship, Miller. That is a
63, kindly to pull.
63. Okay. Apart from all this, the correctness of Ramkumar Gijoria case was referred to a three-judge bench in Karan Singh Jadhav. A perusal of para 6 of the referral order clearly shows that the bench was echoing the ratio of the three judges bench in Ashok Kumar Sharma's case, though there is no express reference to the said case. However, when the matter came up before three judges, the reference was not answered. And even after noticing that the Ramkumar case so and so, the court, however, denied relief to Karan Singh Yadav, the particularly holding that since the application was never appointed to the post at the length of the, it was not possible to grant any relief so and so. Then Millard, kindly come to Millard. Next judgment I will show right Millard. Although it's a caste certificate, 2024 2 SCC page 716. Sorry, 2025 SCC online. 2025 SCC online. Paragraph. SCC online page Miller 716. 2025 SCC online page 1125. This is Mohit Kumar appellant versus State of Uttar Pradesh. Bench presided over by Justice Datto. Have you handed over? Mr. Bhattacharya?
The copy is not there with us.
Are bhai, show it from the iPad.
It was just now sent. Copy korte patan.
You read out the portions. I can follow. I can follow.
Kindly excuse me. Well, paragraph 14. What follows from the above decision is that irrespective of whether an aspirant for public employment belonging to a particular community like SC, ST, OBC, the status claimed by him for being accorded the benefit of reservation is per se not decisive. Such status has to be certified by the competent authority upon following due process and identification that the aspirant is what he claims to be. In Srinivas Prasad Shah, the requirement of production of a certificate from the competent authority was held to be mandatory in view of the statutory mandate. Although there is no such statutory mandate in the facts of the present case, the requirement in question no less mandatory and must be scrupulously followed. Once a process of recruitment is set in motion, all aspirants are entitled in law to equal treatment. There cannot be different yardstick for different sets of aspirants. Non-compliance with the terms of abdomen notification is bound to trigger adverse consequences of rejection of the aspirant's claim. Status by the selecting committee body appointing authority should be choose not to adhere to the same. Having regard thereto, the selecting body appointing authority would be justified in not entertaining the application of an aspirant as a member of the community for whom reservation are permissible. And another one paragraph. The proposition of law, next paragraph 15, as settled by the above decision does not appear to have been doubted in any subsequent decision, and we do hereby endorse the same. This is the, and paragraph 19, it is no longer res indica that terms of an advertisement issued in connection with the selection process are normally not open to challenge unless the challenge is founded on the ground of breach of Article 16 of the Constitution for the matter. Article 14. Once an advertisement is issued inviting application for public employment, it is a responsibility, nay, duty of an aspirant to read and note the terms and understand what his requirements are. If any aspirant finds any of the terms ambiguous and there is a scope for an inquiry inbuilt in the advertisement or is provided by any rules or regulation, an effort to be made first to obtain clarify for understanding the requirements accurately. If no such scope is available, nothing prevents the aspirant from seeking clarity by making a reprehension. Should such clarity be not provided, the aspirants may participate in the process without prejudice to his rights and may question the term even after he is not selected. However, if the aspirant does not make any such effort and takes a calculated chance of selection based on his own understanding of the disputed term in the advertisement and letter, he emerges unsuccessful ordinarily. He would not be open to him to challenge the selection on the ground that the disputed term is capable of being understood differently. In such cases, the court should be loath to entertain such plea of ambiguity while preferring to accept the recruiting authority's understanding of the sector. This is for the simple reason that the recruitment authority is the best judge of what is requirement and are what in such understanding of the recruiting authority that would matter most in cases brought up before the courts. Hence, after commencement of the process, wherein aspirants have participated without raising any demur as to what particular terms means, even if of the terms be ambiguous, as the court should lean in favor of the recruiting authority. My lord, your lordships have delivered passed an order on 26 November 2025. Tanmoy Maiti. The petitioner participated in the second SLST 2025. Prior to filing in his application form, he applied for a certificate under the economically weaker section category. The said certificate was issued to him on September 10, 2025. Grievance of the petitioner is that despite opportunity by the commission to update the details of the candidates in the concerned portal, such portal did not provide any option for updating the EWD's category of the candidate. It has been submitted that petitioner is an extremely meritorious candidate of physics and he should be permitted to avail the benefit of reservation. Submission made by the petitioner is opposed by the learned counsel representing the commission. It appears that the result of the written examination and the interview list has already been published by the commission. The petitioner, for any reason whatsoever, was unable to upload his reservation certificate within stipulated time period. Had the petitioner approached the court at the very first instance, when he was unable to upload the document, the prayer for the petitioner could have been considered. At this stage, allowing the prayer of the petitioner for updating his reservation certificate may amount to unsettling the interview list prepared by the commission. It has to be kept in mind that the selection process is being conducted by the commission in compliance of the direction passed by the honorable court, and a deadline has been prescribed for finalization of the same. In view thereof, the prayer for petition cannot be allowed. Well, these are my submissions.
When was the result declared?
Result declared 7th November.
Mr. Shanal is also there.
I've come up probably right time.
Mr. Sannal,
I'll hear you.
Is he appearing? In which matter?
Can one.
Can one কি আছে? Can one?
এই তো।
ওখানে বলতে পারিনি, তুই এলে বলবো, আমি বলতে পারিনি, চলে এসেছি। তোর অ্যাবসেন্সে কি করে বলবো? তোর হয়ে কেউ নেই না, কেউ ছিল না। তাহলে
It is applied for addition of party.
যাস না, তুই এখানেই বলবি। আমি বলছি দুটো সময়।
But he has applied for addition of party. We will file our affidavit in that.
They are opposing the writ petition, is it?
They're opposing the writ.
Oh, they are opposing. I don't know. Sorry. But one request can I make to your lordship? It's just excuse me. But today I am very badly pressed. But item number 7. Today and tomorrow I am very badly pressed. But item number 9. Item number 9 can be taken up on Wednesday or Thursday. This is my request only.
Who's there in 9 and 10? 9 and 10, you say?
9.
Only 9.
Only 9.
Who's
Others
there in
matters
9?
But just I inform you also whenever.
I think Mr. Dasgupta will be there.
Just Miller, kindly accommodate. Miller, I am very badly pressed.
All right. As and when it is called up, just remind. Let me see what can be done.
Miller, can I, with your lordship's leave, Miller, can I go?
Yes.
Well, I will be very, very concise because it might be in all probability will be the same submissions might be. But just your losses to
Same submissions as that of the
commission, I believe.
commission.
That may, my lord. Just, my lord.
Who are the applicants?
The applicants are already declared as EWS candidate and they have applied.
All right.
Before the date of notification for recruitment.
So you all were holding the certificate prior thereto.
Exactly. Now you
want to oppose them because if they are added, then your chances get minimized.
No, in that, it is in a way look into this. My submissions ineligible candidates is allowed to participate, that will affect my interest. They are ineligible on the date of publication of the notification. Why I just that will tell you. The page 24 of the writ petition.
Yes.
Definition clause R2.
24 of the writ petition.
This should be 2R.
Yes, the definition. Yes.
Your losses will find means a category of reservation in respect of other categories of reservations, if any, enforced by an order of competent authority as at the last date of receiving applications as may be notified pursuant to the advertisement. So therefore, they have to hold that certificate by the last date of receiving online applications. That they do not. Then your losses kindly see the same clause at page 141. Notification.
The submission of the petitioner is that the authority went on extending the time. It is not that the petitioners seek extension.
That is absolutely factually wrong submission.
The addendum notices are there.
They applied for certificate even after the notification.
Yes.
That's your losses.
Page 128.
Give an example, your lordships. Page 128. Kindly take note of the fact that the recruitment notification dated 30th May 2025. Now your losses will find, and last date was 21st July 2025. These are the two dates. Now take one or two example. Your losses will find first name Mamata Samanto. In respect of her application from the bottom Mamata Samanto's particulars. Second one, online application date EWS 7th August 2025. So it is the after the notification. This is the chart kindly have a look. And if your lordships see income certificate issue date 18th June. So he prepared himself or herself even after notification and applied. These are the particulars required documents. He started collecting that during the process started and ultimately applied online application when the time was over. So how could he say that this is the fault of the authorities? This is his own fault. Similarly, your lordships will find the next one, Shumon Jana, 17th August 2025. Now your losses will find the Arup Pal, 24th June applied after the notification issued. Everyone applied either after the last date or during the recruitment notification. Most of them after the last date. Kindly your losses may consider it. Your losses will find Joroth Karupal, page 129, 10th August 2025. Now, one or two might be here and there, but that's is a jumbled up. He should have made it one for one if you write for him also separately. But that case, now delayed eviction, this is one case. This is not correct. Now, delayed by the authority cannot be imposed upon the other authority. One has to get it. Suppose your lawsuit's result published after the application. Can he take the result published application? Therefore, I should be allowed to submit. This cannot be malad. This goes against the rules. Rules say so. Rules there is no malad relaxation clause. Doesn't have. One has to go by the rules. Now there are your lordships will find page one example malad. Page 79. Kindly come to your lordships.
না যেকোনো একটাতে হতে হবে ঠিক
Yes.
Now, losses kindly consider this candidate already belongs to OBC B category. How can he apply for EWS? He cannot. He already belongs to either one he can get. She is already belongs to OBCB. So these are the factually and rules say so notifications are submission. Oh, then it's okay, the other এটা part of the petition নয়
না এটা পরবর্তীকালে দিয়েছে
just a second yellow. No, I don't know factually. I take your losses. এটা ওকে একটা কপি দাও নালে কি করে হবে. This is your losses kindly take issued by the commission. That's different. Kindly have a look at the note 1. This is issued by the commission. All the above documents should have been issued on or before 21st July 2025. But as I placed before losses, most of them are not. 1 or 2 exception might be there. But that is good. Kindly see then. In case of continued EWS, that case is not here. The application before the competent authority should be on or before 21st. That's the last date. Suppose I have already a certificate that is going to expire. If I show an application that I have made it in between, then I can be allowed. This is the. So this is not the case here, lawsuit. But this should not be also there. We are opposing on this. The one, if you have knows that it goes to July, and suppose your lawsuit ends on 21st July or 15th July, it's not sure that he will be given again. Then how can he be allowed to be applied by the commission? Clear to your lordships. EWS certificate year-to-year basis. This year I can have because of income of the family. Next year I may not have it. This is a very, very privilege given to the candidates. One should not misuse it. Because his misuse, because of his or her misuse, someone will be deprived. So this is martial law. That's good. These are my answers.
May I start because Mr. Khanna's presence is required.
No, wait. State is there.
One, only to what Mr. Bandopadhyay has already submitted, I'll just add one sentence to that, My learned friend for the petitioner has relied on Haryana staff selection. Your lordship will find in the internal page 7 of that order, the Honorable Supreme Court, I stand corrected. The Punjab and Haryana, the High Court at Punjab and Haryana has been persuaded by 2 judgments of the Honorable Supreme Court, internal page 7. One is Ram Kumar Gijroya and Charles K. Scaria. Now, Charles K. Scaria has been distinguished in the judgment cited by Mr. Bandopadhyay in paragraph 50.
1-5?
Yes, the first judgment which was shown, 2024-1, SCC 448, Divya. In Divya, if your lordship kindly comes to paragraph 50,
yes.
Charles K. Scaria has been distinguished that why those line of cases need not be followed. And Ram Kumar Gijroya, if your lordship kindly, this was referred to but not cited by Mr. Bandopadhyay, Karan Singh Yadav, 2024-2 SCC 716. By this judgment, Ram Kumar Gijroya was referred to a larger bench. After departing with the view in Ram Kumar Gijroya, and also 2 paragraphs will be relevant there if your lordship kindly takes Karan Singh. 3 paragraphs, from paragraph 4. We have heard the learned counsel on both the sides and perused the record, including the judgment of this court in Ram Kumar Gijroya. In Pushpa, which was referred to in Ram Kumar Gijroya, though the applicant had moved an application much prior to the date of the advertisement, the office of the competent authority took considerable time to make required OBC certificate available. It was in such circumstances that the learned single judge of the Delhi High Court held that the applicant cannot be made to suffer for lapse on the part of the SDM office in issuing the OBC certificate. In Gaurav Sharma versus State of UP, a full bench of Allahabad High Court disagreed with the view expressed in Pushpa and held that even claims made under the OBC category are to be made before the cutoff date prescribed in the advertisement. In Rakesh Kumar Sharma versus State, this court held that the eligibility criteria or condition are to be considered on the date of receipt of the applications. In view of the acute problem of unemployment, whenever few vacancies are notified,
by any public authority, it is common that thousands of applicants apply for such posts. If the applicants are permitted to rectify applications after the cutoff dates, the same would render the scrutiny process indefinite. In course of such recruitment process, many persons, though they belong to the OBC category or SC category, might not have obtained the required caste certificate before the cutoff date. Such persons, being law-abiding and being conscious of the bar contained in the notification of the cutoff date, might not have applied seeking employment. In case the authority starts accepting caste certificates subsequent to the prescribed cutoff dates, whenever a candidate approaches the authority, the remaining candidates who had not applied would definitely be affected. If the applicants are allowed to submit certificate in proof of their claim of reservation subsequent to the notified cutoff date, it would create administrative chaos. In practice, for every advertisement, there are such belated claims claiming reservation, though the candidates did not submit certificate from the competent authority before the cutoff date. In view of the general importance of the question, we are of the view that the issue which fell for consideration in Ram Kumar Gijroya requires to be considered by a larger bench of 3 judges. Accordingly, we refer the matter for consideration by a larger bench. Therefore, both the foundation has been doubted by the Honorable Supreme Court subsequently of the Haryana staff selection judgment. The other point, and even this Gaurav Sharma versus State of UP has been looked into by the Honorable Supreme Court in 2025 SSC online, which we are giving a copy, the commission is giving a copy in the course of the day.
All right, in reply.
In reply, I start from Can 1 application.
Yes.
In page 26 and page 27, some of the applicants' online application is there, I believe. And they mention EWS. First question, when they mention? Before 21st July 2025 or after 21st July 2025? Because my answer is very simple. And because of that dint of that 30 July 2025, first time they introduce this class, not before that. Because SC, ST and PH, these 3 category and others was mentioned, all others. Later on,
how can an advertisement, the application has been shown where category EWS is mentioned on the day of the application?
After 30 July. That is edited application. That is after 30 July 2025. Again, I might place the notification.
No, don't place the notification. The application date is 10th of July. And this is after.
It shows, my lord.
Where is it?
Edited. It is fact, my lord. Edited.
This one, please show that this is edited, Detective Dinto.
We have given a copy to my lord.
You have?
We have given a copy. Formal copy ta dilo.
Suprabhat Mahanta?
ওই তো গোপার হাতে এটা কি
না এটা না যাই হোক
the category is
my instruction is that, my lord. Now, my lord, my instruction is so. Now, my lord, I just kept aside which my learned friend, my lord, Mr. Shanal, my lord, and senior friend, place that document verification. Kindly take it. That document verification. What the state did it. Even SSC did it.
That is not edited. The EWS is they have given.
From the very first.
And the writ petition is pending before court number 25, my lord, where the contention of Suprabhat Mandal is that I had filled up the form, but I was not provided with the certificate with
For the argument's sake, my lord, I accept it. Now, my lord, what is the rule? In rule 2(1)R says reserve category will consider up to 21st July 2025, not beyond that. Now, my lord, what they did it in their document verification format. Kindly take which my learned senior friend handed over.
Yes.
My lord, the first note. All the above documents should have been issued on and before 21st July 2025. Stop here. Thereafter, my lord, in case of continued EWS, the application, whatever the application before the competent authority should be on and before 21st July 2025. The mere application, they accept it. So that is.
But then that is a continuation, continued EWS.
Yes.
Is any of your case a continued EWS case?
It will establish if they give opportunity. There is no such mentioning of continued EWS. There is no such provision.
In any of your petitioners.
I have to take instruction, my lord. There is no such provision. My contention is that, my lord, there is no such provision. Give one instances from the statute, there is any provision of continued EWS. There is no such provision of continued EWS. Why? My lord, kindly turn page number 105 of my writ petition. It never be. And I will place the central government FAQ as well as the state government FAQ. My lord, kindly take page number 105. It never be. This term never be used in the case of EWS, because EWS is a 1 year. My lord, kindly take it. Certificate number, got it, date, now valid for the year such and such, that is financial year. So any certificate that is for a particular financial year, so there is no such terminology used in continuous EWS. Number one. Number two is that, my lord, what type of document it's required. My lord, from when you ascertain as a EWS, kindly turn page number 118-19. That is what, take 119. আর্থিকভাবে দুর্বল শ্রেণীর শংসাপত্র পাইবার জন্য প্রয়োজনীয় নথিপত্র। All this, my lord, we have to gather. What we have to gather, my lord, kindly see, there is a income certificate entry 9. So it starts from income certificate from the panchayat. So, my lord, it is required. And not only that, my lord, I also annex the memorandum of the West Bengal government, page number 120, and the FAQ regarding economically weaker section in force and service under central government. Both I annex, my lord. From that memorandum itself, it is evident the validity of EWS certificate in para 7, page number 121. Yes, my lord. EWS certificate is valid for the financial year of issuance certificate. Same unit. Got it? Para 7, my lord. And my lord, my planet senior pen, although my lord, I instructed that this says in the advertisement there is no such mentioning of 10% reservation. So if necessary, we will not give the benefit of that. They can't say so.
No, 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 they are not saying so.
Oh,
They are not saying.
it is instruction, my lord.
No, they are
Yes,
not
yes,
saying so.
My lord, kindly see, my lord wants to know that whether the all others is mentioned. Kindly see same persons online application. Sumonjana.
Same page, my learned friend referred 122. Well, Mr. Sanyal said that OBC, if one have the OBC, malad cannot be reservation for EWS. That is also mentioned in 120.
Yes, yes, I will deal it. I will deal it. My lord,
No, I
kindly,
did not follow. What is this?
my lord, kindly see same persons two application. In one second page, my lord, kindly see first page and second page. In first page, there is no such category mentioned. Got it, my lord? In the second page, after edit, my lord, got it. Same person. It is downloaded from the website.
কোনটা এটা কার এটা
সুমনজানা
সুমন জানা
21 জুলাই এর আগে তো তোমরা কোনো কিছু করতে দাওনি তিনটে ক্যাটাগরি লিখতে আমি দেখা দিচ্ছি
And the same document was shown as OBC. What you showed, it is the same thing.
No, my
one of them is
says that one of the
one is reservation OBC A or OBC B.
So that is different.
For the reservation of EWS, that Mr. Sanyal Sol Malad says one of the candidate malad having OBC, malad is asking for reservation of.
No, what he is showing is that one candidate filed 2 applications. That means possibly one is after the editing, that the category has been incorporated.
Malad subject to correction, malad category, malad since malad it was pending, malad category probably malad A and B for malad editing, not for the EWS.
EWS, no, one page 166.
There is provision for EWS editing.
First time 160.
Directors are required to mention the category, caste, class, EWS, PH.
It was till 12th of August.
5th August,
Our online application.
12th August.
5th August.
OBC
Please come.
Yes, everyone.
Editing has nothing to do with acquisition of the certificate. A confusion probably is there in the petitioner's mind that edit option means acquiring the certificate.
My lord, and another thing, my lord, this says in pursuance of the Purobi Das matter, my lord, today my learned senior friend not place the OBC order, my lord. Kindly see the OBC order, whether there is any mentioning about that extension.
All right, all
My
right.
lord, there is no such mentioning, my lord. On the last occasion, I also placed it, my lord. So there is not about OBC, my lord.
Petitioners claim
Before 26.
a reservation under the economically weaker section category.
And
WSC
that order will not be, that order will not be applicable because my lord, approached this court long before, and that too on the score of that, my lord, they have yes, it uploaded, and my lord, they're not uploaded. We always within 26 September. That is a distinguishable point within the
Memo at page number 166 does not refer Puravi Das order, my lord. That's my submission.
দেখুন না
Puravi
কি বললাম?
পরে রেফার্ড হয়েছে
না আগে রেফার্ড হয়েছে
সরি
Right.
Puravi Das
They
referred on
appeared
30
in
July
the
2025.
আচ্ছা অর্ডার দাঁড়াও বলতে থাকলে তো হবে
second SLST within bracket 80 examination in response to the advertisement published on 30th May 2025. The last date for submission of the online application was 16th July 2025, which was later extended till 21st July 2025. The fees for the examination was applicable in respect of two categories. Not applicable, was segregated in two categories. First, for general and OBC candidates, and the other for SC/ST and PH candidates. The note appended to the advertisement mentioned that for consideration of belonging to reserved categories, the candidates, the certificates issued by the competent authorities of only the government of West Bengal on or before the last date of receiving online applications shall be treated as valid documents. Step. The Commission published addendum notices on 30th July 2025, 5th August 2025, and 22nd September 2025, permitting updating/editing the caste category. Step. The addendum notice dated 5th August 2025 permitted candidates to mention their specific category, including class, including caste, tarpor class, EWS or physically handicapped category. Stop. The edit option which was provided, not which was provided from 5th August 25 to 12th August 2025. Stuff. The case made out by the petitioners is that they applied for obtaining the EWS certificate but due to the delay in issuing such certificate, they could not disclose their category at the very first instance, but the candidates received the certificates prior to the last date of updating the category, that is 26th September 2025. Stuff. It has been submitted that the EWS certificate is valid for a financial year. Stop. These certificates relied upon by the petitioners are valid from 1st April 2025 till 31st March 2026. Stop. It has been submitted that the authority ought to treat the petitioners as candidates of the reserved category, relying on the certificates annexed by them in the instant writ petition. Stop. In support of the submission that the authority ought to give credence to the EWX certificate the petitioners rely on the judgment delivered by the Honorable Punjab and Haryana High Court on 24th March 2023 in LPA 1199-2019 in the matter of Haryana Staff Selection Commission versus Subhash Chand and others, wherein the court relies on the principle that proof of reservation reservation claim can be submitted later. Stop. The appeal preferred by the appeal preferred against the judgment in the matter of Subhash Chand within brackets Supra has been affirmed by the Honorable Supreme Court. By judgment dated 31st January 2024 in Civil Appeal number 6395 of 2023 in the matter of Haryana Staff Selection Commission versus Subhash Chand and others. Stop. A reference has also been made to the judgment delivered by the Honorable Supreme Court in the matter of Dolly Chanda versus Chairman, JEE and others, reported in 2005 9 SCC 779, and the judgment delivered by the Honorable Supreme Court in the matter of Ram Kumar Gijroya versus Delhi Subordinate Services Selection Board and another, reported in 2016 4 SCC 754. Paragraph, the prayer of the petitioners has been opposed by the respondents. Stop. An application for addition of party has also been filed, has been filed in the writ petition by candidates claiming themselves to be members of the EWS category. The applicants claim to be holding the reservation certificate on the date of the advertisement. Stop. According to them, the candidates who were issued the EWS certificate beyond the prescribed time period mentioned in the advertisement have to be taken as ineligible for being treated under the reserved category. Stop. Such candidates ought not to be permitted the benefit of reservation. Stop. Paragraph. Learned Counsel for the Commission submits that the advertisement specifies the date within which the documents for reservation are required to be acquired. Stop. Any document acquired after the last date cannot be relied upon. Stop. In support of such submission, the judgment delivered by the Honorable Supreme Court in the matter of Divya versus Union of India and others, reported in 2024 1 SCC 448, has been relied upon. Reference has also been made to the judgment delivered by the Honorable Supreme Court in the matter of Mohit Kumar versus State of Uttar Pradesh and others, reported in 2025 SCC Online SC 1125. Reliance has also been placed on the order dated 26th November 2025, passed by this bench in WPA 26420 of 2025 in Tonmoy Maiti versus the State of West Bengal and others, wherein the court was pleased not to accept the prayer for granting reservation to an EWS category candidate, as the writ petition was filed. Now, as the candidate approached the court after declaration of the result of the written examination and the interview list. Stop. The paragraph. The judgment passed by the Honorable Supreme Court. Now, the reference to the larger bench made by the Honorable Supreme Court in the matter of Karan Singh Yadav versus Government of NCT of Delhi and others, reported in 2024 2 SCC 716, referring the judgment in the matter of Ram Kumar Gijroya within brackets Supra before the larger bench, has also been brought to the notice of the court. Stuff. Next. The respondents pray for dismissal of the writ petition. Stuff. I have heard the submission made on behalf of all the parties. Stuff. The advertisement relying on which the petitioners applied for recruitment is dated 30th May 25. And the last date for filing the application form as extended by the commission was 21st of July 2025. Stuff. As per the advertisement, the reserved category is to be identified considering the certificates issued by the competent authorities of this state. Stuff. In the instant case, the writ petition contains a chart disclosing when the petitioners applied for obtaining the certificate and when the same were issued by the authority. Stuff. It appears that the process of collecting documents required for obtaining the EWS certificate started after the notice of after the recruitment notice was published. Stuff. Issuance of certificate took some time and the same was issued after the last date for submission of the online application. Stuff. According to the petitioners, as the certificates were issued at a later point of time, accordingly, they could not submit the same within the due date. Stuff. The court is of the considered opinion that had the petitioners obtained the certificates prior to the last date of filing the online application, then they could have got the option of updating / editing their application forms in terms of the addendum notices issued by the commission. Stuff. In the instant case, none of the petitioners possessed the EWS certificate till the last date of filing the application forms. Stuff. In fact, from the chart annexed in the writ petition, it appears that the online application for obtaining the EWS certificate started long after the deadline for filing the online application expired. Stop. If the reservation benefit is granted to the petitioners, then similarly circumstanced candidates who received their certificates after the last date of filing the online application may be deprived the scope for being treated as reserved category candidate. Step. The rule relying on which the reservation is granted prescribes that the reservation certificates ought to be issued by the competent authorities on or before the last date of receiving the online applications. Step. The submission of the petitioners that the Commission permitted updating or editing the reservation status does not imply that candidates who obtained the certificates after the last date could have updated or edited their option relying on those certificates. Stop. Had the certificates been available prior to the last date of filing the application form, comma, then only the question of updating or editing the option arises. Stop. Any certificate which is issued beyond the prescribed period cannot be given the benefit of reservation. Stop. The the judgment in the matter of Ram Kumar Gijroya mentions about a caste certificate. Stop. A caste certificate. Now, the caste of a candidate and the reservation under the economically weaker section are completely two different matters. Stop. One cannot be equated with the other. Stop. A caste of a candidate, not a, the caste of a candidate is acquired on the date of birth. Stop. The certificate is issued only to certify that the candidate belongs to the reserved category. Stop. By the issuance of a caste certificate, comma, the caste of a candidate cannot be acquired. Stop. Next. In the certificate issued for the economically weaker section of the society, comma, the same is issued relying on the assets possessed by the candidate. Stop. The asset, now the same is not static and it keeps changing or vacillating from time to time. Stop. It is for this reason that the economically weaker section certificate is valid only for a period of 1 year. Stop. The certificate is required to be issued afresh if the same condition persists, if the same economical condition persists. Stop. The EWS certificate has nothing to do with the birth of a candidate. Stop. Next. The Honorable Supreme Court in the matter of Mohit Kumar within bracket Supra the court mentioned that after commencement of the process wherein aspirants have participated without raising any demur as to what a particular term means, comma, even if any of the terms be ambiguous, comma, the courts should lean in favor of the recruiting authority. Stop. In Divya within bracket Supra, the court held that determination of eligibility cannot be left uncertain till the final stages of selection, comma, since that would lead to uncertainty. Stop. If rules prescribe the last date on which eligibility should be possessed, comma, any relaxation would prejudice non-applicants who, for want of possession of eligibility, would not have applied. Stop. Selection would then be relaxation, not selection. Relaxation would then be selective, comma, leading to discrimination. Stop. Paragraph. In the instant case, if the prayer of the petitioners for being provided relaxation is allowed, comma, then there may be several other candidates who may have obtained their EWS certificate beyond the prescribed period of limitation would be denied such benefit. Stop. The same would be arbitrary and will certainly be discriminatory in nature. Stop. In view of the above, the prayer of the petitioners cannot be allowed. The writ petition fails and is hereby dismissed.
Only one thing is
Can allowed.
one
One
thing.
thing must be pointed out that the petitioner did not point out. Page number 81 shows a
Yes,
certificate which
I
was
want to.
issued prior to the date of the last date, yet he applied as OBC B and did not rectify it. That case of petitioner 8 is different from the rest of the petitioners. But page 81, your lordship.
Why I explain that?
18th July, আমি
Yes.
বলছি বলো না, তুমি তো বলোনি তোমার বলার সময়।
আমি ওটাতে
18th
indicate
July
করতে যাচ্ছিলাম।
2025, he has obtained it before the last date. Yet he gave the category of OBC B. Your lordship will find at page 79. The form he has annexed at page 79. So he had option till 5th of August to rectify it. He did not rectify it. That is a separate case, factual situation of the P8.
May I, because of that, kindly turn page number 81. Sri Ashish Kumar Kole belongs to the Shodgop. Got it, my lord? Kindly turn, my lord, page number 168.
168?
Yes, my lord. Shodgop is a category. Earlier, he was not categorized as a OBC. Later on, the state government of West Bengal, they categorize this Shodgop category as a OBC category, but they not issued the certificate. And for that reason, my lord, kindly turn page number 168.
Yes.
There are FAQ. My OBC status has changed vide new labor department notification dated such and such. What do I enter, my old OBC status or new OBC status? I do not have a OBC certificate as yet, as I am a new entrant. / my OBC category has changed. My certificate is an old and a manually issued one, and new certificate has not been issued. So what to do? If you have an old certificate, enter that number for future reference and verification. If you are a new entrant and do not have a certificate, leave the field blank as it not a mandatory field. It is made clear that actually physical verification of category details will be conducted only after publication of the result of the written examination. So for that reason, because of that short scope category, my lord, I mentioned it, my lord. And even in my my lord, page number 81, it is mentioned that I am in a short scope category, my lord. I entered my photo and signature. That is, so the reason is that, my lord, because that Shodgop
Then he'll be
community.
treated as OBC and not as the EWS.
Yes.
That can be done. Commission?
That is not the
Not in the REIT, in the commission, whatever is there.
But he has already applied as OBC. If he during
Yes,
verification he could have produced certificate.
here we are considering only EWS.
Because
His prayer that now consider me as EWS.
No, then whatever he has declared
yes.
will be.
That the reason because of that at that point of time Sadgop was there. Later on,
Alright,
it is a
alright.
new end. Grateful, my lord.
6.
No, I'm for the petitioner. To my lord, worship ki rakom aage experience ta. Now I tell you, lordships, my lord, the application.
This is also SLST matter.
Because
Is this SLST matter?
SLST matter.
All right.
Up to 10 is SLST.
No, my lord, my application form, page 21.
Yes, 21.
The petitioner applied for assistant teacher in Bengal. My lord, I find it, my lord, at least standard academic qualifications. I don't say, my lord, too much good or too much bad, but it's good. My lord, your losses will find the column, last column, academic qualifications percentage.
Hmm.
My lord, see, mentioned percentage went on. My lord, post-graduation 7.16 and B.Ed 9.21. My lord, this is percentile, she mentioned. My lord, if you losses kindly come to page 12. My lord, total credit value of the program 84 and cumulative grade point average 7.16. Well, he has exactly mentioned as full marks 84 and 7.16.
Hmm.
And the second year losses, B.Ed qualification, page 13. Well, credit value 80 and SGPA, that cumulative grade point average 9.21. Exactly, she mentioned that.
Hmm.
My lord, the commission at page your lordships, West Bengal School Service Commission, my lord, this result published. If your lordships kindly take your lordship, educational page 22.
Hmm.
Rules ta koi de.
Yes.
My lord, kindly see educational score 6.
Hmm.
My lord, if it is, my lord, converted into percentile, this will be 10.
Hmm.
Admittedly, my lord.
Hmm.
My lord, he didn't probably understand that or that. And the cutoff mark 66, that would be 67. Obviously, +4 will be. So this is the point, your losses. My lord,
What is to be? What is the error on the part of the commission?
I've never said, my lord.
What you want? No error. Petition dismissed. Nothing.
No, no, my lord, kindly at least, my lord, kindly consider the rules.
What?
Just your lordship, page rules 15. Maybe your lordship have come across in other matters. Joseph, এটা Joseph? 11. I just gave, take your losses. Oh, 11 to পাচ্ছি না এখানে. Just a minute, my lord. 11. No, mistake clause টা কোথায়? 15. 15. That I. No, kindly. This is governed by these rules. But after Bengali teacher, mathematics weak, obviously she or he will be like me.
No, she is not doing any mathematics.
No,
she is disclosing her marks.
Percentage, he didn't get.
The other 3 she could write properly.
No, that's percentage. That's
obviously
here
that is what is
new marks
required.
Percentile. He quoted the percentile.
Not
in the other marks at percentage.
Not fit for the job.
Bengali teacher fit for
whoever.
Bengali. In losses, kindly see the rules at least.
Yes.
15. 15.1. If prior to or after recommendation or during course of selection process, any candidates found to have concealed or suppressed or misrepresented or made false declaration in his application or at any stage, mistake or fault committed by the commission doesn't arise, granting a recommendation rules otherwise, such candidate will be treated disqualified.
Yes.
But he has not concealed anything. See.
She made a false declaration.
This is not declared false, I tell loss. Kindly, false is something
incorrect.
That I got 2, I mentioned 20. This is false. Whatever I got, I mentioned it. Kindly consider.
Be happy with that.
No, that's two harsh views of your losses.
No, nothing
Two
doing.
harsh. Kindly consider
If
that.
the commission is kind enough to do it, it is on their own, but the court is not going to interfere.
At least direct the commission to consider.
No direction. What is the stand of the commission?
Milord, our stand is, Milord, from July to November, there was some window. If we allow this person, Milord, to rectify this defect, then a floodgate.
July to September window. Where is that?
Well, he didn't understand the window scope because he thought, he thought that
He thought always doors closed, no windows open for you.
well, at least your lordship's window open.
In the 2025 judgment, there's a line which says that one who participates should be vigilant of what is coming next. The notification and advertising.
No, that's not the window. He didn't understand that. He said that I have mentioned whatever in mark
That is
sheet
the
mentioned.
reason he should
Is
not
the
be.
window open or not?
Information brochure, Milord, kindly comes to the information.
No, I'm not saying that window not. I'm not going into those contention. I'm saying, this is not.
From July to November, Milord, there was no approach made. Milord, today we are in the month of December. The interview list and everything is now settled. Milord, we have already published it. Though, Milord, in terms of your lordship's order, we have clarified in the website.
That is different. That is not in personam. That is in rem. Then
Milord, July to November, Milord, had he, assuming, Milord, he understood the difficulty, then he could have, Milord, approached.
Right. See, if
I tell you, lordship, this is I got page 22 once come, your lordships. Let me try, your lordships, whether I can convince.
22.
22. Now, after I got this, then I tried to realize what happened. Then I found this is the thing. Now, your lordships, kindly see educational.
This is late realization, and the court cannot help.
One point more.
No, sorry.
6. How could I be assigned 6?
That is between
6,
you and the
nowhere.
commission.
I could have understood they have rejected it. They have not rejected, Mala. They have given 6.
Yes.
I could not have been given 6. Because I tell you, lordships, why? Kindly have a look at this. Then you, commission applied his mind. Kindly see. Kindly have a look at this. Page 11.
Page 11 of the
rules. Now kindly see percentage of 10. 60 above 10. If it is converted into percentage, my is 60.66.6. Then I would have get 10. Now they have given what 6 must be below 50%. I have not got below 50%. How could they give 6?
Below 50, you've disclosed yourself.
No. Your losses can be look. I have not disclosed percentage. I have given percentile.
The column that you filled up.
That is percentage.
Then
well,
they will take it as below. Nothing
below.
doing. Sorry, sir. Nothing doing. Please come. The petitioner participated in the second SLST within bracket 80, 20, 25 within bracket class 11, 11 and 12. 11 and 12, just imagine.
I could have made a mistake like this. I'm admitting, Mala.
Nothing
I'm a
doing.
student, I could have.
Could have you
And I have made this sort of
face the consequences.
I have faced that.
At the
in
time of
form,
filling
if
in
losses get it,
the
everybody will make a
application
mistake.
form,
Let's make a study of this.
instead of now in the application form, instead of disclosing the marks she obtained in the post-graduation and B.Ed examination, she erroneously disclosed her percentile. Stop. After declaration of the result, she noticed that the application form was not properly filled up, for which she did not get the marks as she ought to have received in accordance with the score she obtained in those examinations. Stop. Prayer has been made to direct the commission to rectify the commission to permit the petitioner to rectify the error and to consider the actual score which the petitioner secured in the post-graduation and B.Ed examination. Stop. Paragraph. Submission of the petitioner is opposed by the commission. Stop. It has been submitted that a window was provided by the commission to candidates to rectify all errors.
It is incorrect, not window. It was open for him to approach the commission from July to November. There was apparently no window.
Then how was it open? Suo moto he could have gone. লাইনটা কেটে দিন আপনি লিখুন যে it has been submitted that the petitioner did not approach the commission for rectification of the error prior to declaration of the result of the written examination or the interview list. Stop. After the interview list is published by the commission at this stage, comma, the prayer of the petitioner seeking correction of her marks, not marks, percentage, disclosed in the application form cannot be allowed. Stop. If such relief is provided to the petitioner, comma, similar cases may reach before the court. Stop paragraph. Upon hearing the parties and on perusal of the documents, it appears that the petitioner has disclosed her academic qualification for the madhyamik, higher secondary, graduation, post graduation and B.Ed examination. Stop. In each and every examination, the candidate was required to mention the percentage of marks obtained. Stop. In respect of 3 examinations, the petitioner disclosed her percentage, but for reasons best known, disclosed her percentile in the other 2. Stop. The candidate ought to have been careful and alert at the time of filling in the application form, as any incorrect statement may be treated as an erroneous declaration. Stop. The commission considered the marks disclosed by the candidate as the percentage. Stop. The candidate did not have the opportunity to verify documents at the initial stage. Stop. Because of the difference of marks, comma, the petitioner has not been able to qualify in the qualify for the interview. Stop paragraph. The court is of the opinion that it was for the petitioner's fault that such a problem has arisen, and at this stage, there is hardly any scope to permit the petitioner to rectify the same. Stop. In view of the above, the writ petition fails and is hereby dismissed. Take back the rules.
Rules
কি হচ্ছে? এগুলো পরে দেখান না কেন? ভুলে যাবে। সই হয়নি? সই হয়নি? আপনার ভুল কেন? কি করেছিলেন? কি হবে? Yes.
Lordship, I am appearing for the petitioner's lordship.
Petitioner?
Yes, lordship. I'm paying for short password.
The three matters, 7, 8, and 9. 7 and 8 pertain to a matter similar to my lord's order in Somnath Pramani. Where category change and general to SC and we have carried an appeal from your lordship's order. Mr. Bandyopadhyay in some difficulty today is indicated. May those matters be posted till Thursday. These two matters particularly. And item number 9 for Wednesday. 9 is also very.
Lordship, item 8, Mr. Hall has some difficulty on
Verification already completed.
And item number 9 has been requested by Mr. Bandyopadhyay.
Yes.
Wednesday.
Right. Wednesday.
7 and 8 we are also praying for.
And all three matters are the general 2S.
9 is
No, 9 is different, my lord.
All right, then wait. 7, who's for the petitioner? You seek accommodation. There is a request from the commission. I place it on Wednesday.
Yes.
By consent of the parties, take down an order, please. 7, by consent of the parties, list on 10th. Eight.
Lordship, Mr. Thor, I'm praying for not to be on the ground of Mr. Thor. Maybe kept tomorrow. It is similar to this matter.
Then 10th.
10th. Let it appear on 10th.
Some difficulty on 10th. Tomorrow.
Tomorrow the other side will not be there.
Side will be there. This is the same SLST matter, ACST matter. This is like just like Somnath Pramani.
Yes, it has been carried in appeal. Wait for 2 more days. All right. Same order করে দিন তো by consent Wednesday. 8টা. 9.
Item number 9, my lord, I appear for
Is it a similar matter?
No.
All right, it's different. 9, there was a request made by Mr. Bandyopadhyay to place it on the 10th, Wednesday.
The difficulty is, my lord, verification for 11, 12 has already been completed.
All right.
Today or tomorrow, the interview list will be published. My lord, I am praying for a publication of the list of first SLST. Other than, my lord, expiry of panel, OMR, rank jump, all these, my lord. This is my specific prayer, not specifically.
Specific submissions to make, may most humbly be.
My lord, there is a direction from the Supreme Court before this court that this court will ensure. The High Court shall, however, ensure that
Not
none of
tainted candidates. Now it has to be decided who are the tainted and who are.
I am not praying who are the tainted or non-tainted. I am praying for a list. The list will not contain any expiry of panel. The list will not contain any rank jump. The list will not contain any out of panel or any other type of irregularities or OMR.
Yes.
This list may be published.
That means they have to make categories separately for out of panel candidates, for the after expiry, those OMR mismatch and those.
Those are one categories. The category, my lord, where the candidate do not fall under any of the categories.
Not specifically tainted.
To be tainted, my lord. This is
but this an order has also been passed. I do not
no. In respect of my lord, 11, 12, there is no order passed. In respect of Group C and Group D, there is an order passed. But my lord, here is a specification of the category. Let the commission say that these are the candidates. There is a specific prayer, my lord. Let the commission say that these are the candidates who do not fall under any of the category. Four broad categories, my lord, Supreme Court has divided them. One is expiry of panel, one is rank jump, one is OMR mismatch, and one is out of panel, or any other type of irregularity or illegalities. My lord, other than this, a list may be published, because my lord, kindly visualize the difficulty. Interview list will be published. Many person, my lord, we know, my lord, after expiry of panel will be participating. My lord, those vacancies will go. Again, my lord, appointment will be made. So few of the genuine candidates as well as freshers, my lord, they will be deprived of, and they are hurrying up.
Hurrying up because of the Supreme Court deadline. But then, since a request has been made, I'll take it on the 10th only.
10th at the top.
Yes, these matters will be taken up by consent 10th.
But affidavit of service be taken on.
All right, affidavit of service taken on record.
Again is challenging the rules. Your lordship is already hearing a matter.
Rules challenged by the untainted teacher, not fresher candidate.
Now, there are many untainted teachers who are challenged.
Who are permitted, no matter those who are permitted to continue the job till 31st December, they challenge that rule. My lord, only 1 second tomorrow, my lord. 1 second, my lord. Kindly have a look into prayer, my lord. Probably.
Are you participating in this year's examination also?
My lord.
Yes.
Written examination passed.
All right.
My lord, kindly have a look into, my lord, my prayer.
Yes.
Prayer B. Issue a writ in the nature of mandamus as well as the West Bengal Board of Secondary Education to conduct de novo examination strictly on the basis of the West Bengal School Service Commission selection for appointment to the post of teachers of 2016 rules. This is our prayer, my lord. 90%. But graduate examination, my lord, my father died. I got only 40%, 45%. Now 2025 rule, only, my lord, graduate or postgraduate marks in academic, not all through. My lord, intention of the Honorable Supreme Court, 3rd April, 17th April, and 22nd, 26th November, that strictly, my lord, do not hamper the interest of the untainted candidates who appeared in the 2016 rule, 2016 recruitment process. This is the intention of the Honorable Supreme Court, my lord. My lord, if your lordship kindly...
Tell me one thing. The rule was published on 29th of May 2025. The advertisement was published on 30th of May. You have filed this writ petition on 5th of December.
It is true, my lord.
Why?
That, my lord, why, my lord? Because already my instruction is that already 500 candidates, 500 teachers already left out from the, my lord, evaluation after written test.
Yes.
After cut off marks, not only that, my lord, poster vanished.
Poster vanished?
Vanished due to 100% roster.
Right.
And
Now,
not only that, vacancy decrease in physical science. Petition number 2 is a physical science teacher. Vacancy decrease total 323 in physical science. My lord, my lord, if your lordship kindly have a look into the order minutely, already, my lord, all senior advocate of this, my lord, court, my lord, demonstrate before your lordship. I am saying only before your lordship the difficulties.
Yes.
Difficulties of 2025 rule and the, my lord, contention of the Honorable Supreme Court, 3rd April judgment and section 17 of the School Service Commission Act.
All right.
Now, your Milord, I want to tell your lordship one. Please see page 71.
Today or next day? Today or next day?
The lordship has already dismissed his writ petition on similar grounds.
And he not similar ground.
The principles that we have learned from your lordship is not principles akin to order to rule 2. All issues should be covered in one petition. By multifarious attacks, the commission cannot be questioned for its actions. He moved a writ petition on 2nd of December 2025. My lord was pleased not to entertain his petition. Then he comes by way of this fresh petition, with additional grounds, which perhaps in my respectful submission is clearly not permissible. On that ground itself, the writ petition should not be entertained.
All right.
There are two petitioners. There I have not challenged the rule. Here I have challenged the rule.
Why? This is what he is saying. Can
My
you
lord,
come up with multiple writ
No, no, my lord, not come up with multiple writ petitions. That
prepared when? Tomorrow?
Tomorrow, day after, whenever suits your lordship. This, I think, we can handle.
If this matter it suits now only, then we can take it up here now.
My lord.
Because you only prayed for adjournment. He is ready.
This question, yes,
he is ready.
Rules, yes, true. If he is arguing rules, the rules matter is coming up tomorrow. Your lordship is hearing Mr. Dhar.
Yes.
apart from the rules issue, since there is a previous order at page 71, which dismissed his writ petition carried by one of the petitioners, petitioner number 1. In my most respectful submission, this writ petition, if it is
Restricted to two,
I have
nothing.
nothing to say. If it is carried by one once again, the writ petition is at the instance of one is not maintainable.
My lord, defect page 71, kindly have a look into your lordship's order. The defective prayer, but that time we do not know the 100% roster. After we came to learn from paper at the time of the hearing.
What steps did you take to ascertain how the vacancies are declared and all?
That time, page 71, that time, my prayer is defective. For that reason, kindly have a look into page 71, my lord.
Yes.
Page 71 and 72.
Persian.
Petitioner is a teacher of Persian subject.
Yes.
His allegation is that commission
100 point roster is for. Yes, I followed this.
My lord. From the document, the petitioner is a member. According the paragraph 6, prayer of the petitioner for declaring fresh vacancy in the Persian subject in the general category cannot be allowed by the court. It is for the authority to declare vacancy, and the court exercise power of judicial review in such a situation. For that reason, my lord, I challenge the rule. My lord, comprehensive petition I filed.
So this, you did not obtain any leave to challenge the rule. Had you obtained a leave, it would have been otherwise. You did not.
With due respect, I am submitting before your lordship. My lord, not a single, my lord, if your lordship kindly have a look into the previous writ petition, the abatement, not a single line regarding my lord rule.
That is what he is saying.
For that reason, liberty, my lord, with due respect, I am submitting before your lordship. Liberty is not, leave is not required, my lord. This is the totally.
I will request my learned friend to kindly go through order to rule 2 once.
My lord, totally different, my lord, aspect. I filed, my lord, writ petition, my lord. Yes, my lord, that no whisper in my previous petition.
Whatever you are submitting, your learned friend is accepting that. You cannot come up by way of installments. You have a problem. You have to come in one go, which you have not done. Today you are challenging vacancy. Tomorrow you are challenging the rule. Third day you will challenge something else.
Well, here everything I have, my lord.
This cannot be done. Shortcut method. Item number, the petitioner number 1 be deleted. 2 can carry forward. You make a choice. Think it over. Come back tomorrow.
My lord.
Followed?
Not
today.
Kindly keeps the day after tomorrow, my lord. Tomorrow the hearing matters are there, my lord.
Alright.
Other matter, my lord, yeah, Bhim matter, my lord. I also filed, my lord, addition of party that was allowed. And same.
That is different.
Different, but same argument, my lord.
Ijaz.
So, my lord, untainted teachers, my lord, praying for those, this is an addition of party.
Alright. Next. The Wednesday in that case. By consent of parties.
Yes, madam.
Not 11, this is 10. By consent of parties, Budwari.
My lord, tomorrow, my lord.
Day after tomorrow. You get more time to come prepared.
Get fully.
Yes, item 11.
My lord, item 11 is that matter, my lord, where your lordship is, my lord, monitoring that illegal construction over the wetland areas, my lord.
Well, I am the. So I have filed one application, corrected application, my lord. We are the flat owners. We have purchased the flats, and we are staying there for a long period of time. We made an application for addition of party.
You are residing in flats. Do you have a sanction plan?
My lord, this is sanctioned.
Show me who has issued the sanction plan. Where is your application for addition? Can
application is number 7, my lord.
Yes, can 7. Show me that you have a sanction plan and who has issued the sanction.
My lord, this sanction was from Panchayat, my lord. On the basis of that, we are shown. My lord, so far this issue is concerned, this ICMA authority. If your lordship ultimately decides to permit me to be added as the party, I'll be taking one point, lordship, that's a point of law.
that what would be the force of this act after this National Wetland Management Act has come into force.
Firstly, you tell me what is your legal right.
Legal right, my lord. It was a
Who
Vastu
has
land.
issued the sanction plan?
Panchayat.
Does the panchayat have any authority to issue
My lord,
sanction
kindly
plan?
come to. I have given the development agreement.
Development agreement means
There is
nothing.
no other authority which can give the sanction plan, my lord.
Exactly, because no plan could have been sanctioned over a water body. It's a wetland.
My lord, there are the distinction in the act itself, in the schedule. There are certain area of land which were.
Show me that you fall within those exceptions.
Yes, my lord. If
Please.
I am added as a party, lordship, I will.
You show me now, otherwise I'm not going to add you. I'll dismiss it here and now. Show me that you fall within one of those exceptions where permissions can be granted for
Your
sanction.
lordship, kindly then give me some time. Give me 2 days time. I will give everything. Everything I will give, lordship.
All right.
Whatever I have, definitely.
Obviously.
I can.
One of the panchayats is over here. Which panchayat gave you the authority?
My lord, kindly come to us. I have given my deed of sale, agreement for sale.
Sale you forget. You show me.
Agreement, my lord.
Now who has filed?
Areas which are not covered by wetland, whether his DAG number falls under this here and
Let him show. Let him show. You serve a copy of the application, otherwise he also doesn't know. Writ petition has to be served. Did you serve to any of the parties?
No, my lord, we have not received.
None has received. There is another application for addition of party. Same thing. They are residing there and they do not have a sanction. Check up the DAG number, plot number, whether it falls within the semi area or not, so that part construction can be provided, part water body, part see, and then make submission. Otherwise, this case is here for quite some time. From 23, it's going on and on. Now, what is the position?
I have a report.
Yes.
Lordship,
How many more identified and
applications have been made by us, and kindly sees in various paragraphs we have elaborated the difficulties. In a similar matter, your lordship, with court number 25 is hearing, there is again an interim order, and the WBAP, which on the last occasion I had mentioned, those applicants have been dedicated before the chief technical officer for giving hearing, opportunity of hearing, because that was I already apprised your lordship that they were not there since that, and the honorable chief justice has held that since have not been given a personal hearing, so this is washed aside and they should give them a fresh opportunity of hearing.
why are you all doing like this? Because see, the act also says that you need to give them an opportunity of hearing. Then there is violation of principle of natural justice. So it means that you are prolonging the whole thing.
No, your lordship, they have been given the hearing notice. Many times they have not come up. We have
That is different, but at least do.
In one of the paragraphs, there has been an ex parte order which has again been challenged. I would like
That is different, but at least you all follow the rules to identify, to pass an order of demolition. You need to follow the rules.
Lordship, never has there been any violation. You might kindly record my submission.
Whatever, otherwise writ petitions
are being served. Even we are taking that precaution that we are affixing the notices on the residences, so they are aware that something like this is happening. Even after that, there is no cooperation.
Do you all have a website, an official website?
I think.
Just wait. In case there is a website, why don't you publish it in the website that the proceeding is going on, and anybody who doesn't have a sanction, these are the plot numbers. See, there are many purchasers who do not know it. Unknowingly they do it. They fall in the trap of these developers and all these people, and then they lose their savings, their life savings.
Yes.
So this is.
I'm beseeching your lordship that after this matter has been in 2023, after that, and when they were very, like lordship had made in her order, She had stated that no further sanction plan will be given, no further electricity connection. This is being strictly adhered to.
Construction is still going on.
My lord, my sanction.
There are random construction.
See,
I do not.
I cannot identify those constructions.
No, this goes to show, Milord, if he says, I cannot identify the constructions, this goes to show, Milord, he doesn't know whether the construction is being made in a dark number which is substantially water body or partially water body. He must not, Milord.
1 minute, 1 minute, 1 minute. I'm hearing her. Yes. So, whatever has been done, if it is illegal, not in accordance with law, it has to be undone. Let nothing erroneous or illegal be done henceforth. This was the idea, to prevent, right? Now, I don't know what y'all are doing with those already identified. How many demolitions?
Many had been taken care, Your Lordship. Two demolitions had been taken care.
Yes, show the demolitions.
And on the last occasion, to that effect, report has been placed.
Yes, a wall, a thatched roof. Those have been demolished. What about the multi-storied?
Your Lordship, this is before court room number 25. Honorable Commissioner is hearing that
The same property.
the same property.
There may be one property, but you have identified 550 or something, 505 unauthorized illegal constructions.
Apart from that, go down.
Wait. Yes.
Friend also was there appearing along with me on the last occasion. There also there is an entry protection. For these entry protections, we are also unable to.
Interim protections are given only if it is seen that you are doing something not in accordance with law.
But there is slightly different.
All right, then that is only one matter. What about the others?
That is Lordship. Whatever has always fallen from your Lordship, that big fishes, this is the biggest fish we are trying to catch.
Go to the medium ones now.
There are go downs are also there.
See, he is only saying there are go downs and everything. Go, take steps.
Residential complex, which is being heard over there, they are the hugest residential complex. I think he will not be in a denial mode.
Maybe, even if he denies, it hardly matters.
What do you mean? Why?
That very small demolition have been
You
carried out.
demolish only one wall. Partly one wall. How does that change the demography, the ecology of that area? It doesn't change.
I do not want to go as of now because I have ventilated in my report what are the difficulties on the last occasion. Also.
Show me one, the demolition, is anything there? See, the last day's order is dated 22nd of September. So we are in December. That is there. But then the order passed on the last day was 22nd November and today we are in December. What is the progress?
Kindly see, Your Lordship, step by step the progress needs to be. Kindly see paragraph number 1 at page number 2.
Yes.
Page number 2, the last paragraph. The two paragraphs I would rely upon. And if Lordship is, all the paragraphs can be taken into account. Urban Sabujian, Your Lordship.
1 minute. Paragraph page this page 2, last line I can see. But in spite of repeated requests, the municipal authorities and the district administration are not taking action against those unauthorized construction. This is what you stated in paragraph 2.
No, in paragraph internal page number 2, step by step, Lordship was interested in knowing how we have proceeded, whether it was not in accordance with law or in accordance with law. Kindly see.
No, that is a different bench is looking. Page number 2, the very last line.
Yes, this is what we have. This is one of the difficulties because we do not have the apparatus.
In spite of repeated requests, the municipal authorities and the district administration are not taking action against those unauthorized constructions. I have the municipality here. I have the state over here. Tell me where they have not acceded to your request. Show. Please show. Which letter was not accepted by the state administration or the municipality? Please show.
Kindly see the letter dated page number 28. 28/8/25.
28th of August 25, request to provide an updated status report with the unauthorized constructions within.
And at page 32 also, there is a letter.
1 minute. Request, page 28, request to the corporation to provide an updated status report with respect to the unauthorized constructions within the EKW. Will the corporation be in a position to identify those?
No, because we are passing these orders, we are forwarding it to the either the concerned authority or the district administration.
Where is the order?
Order I have, your lordship. I'll just 4/12/2025. Kindly take page 35.
Is the Kolkata Municipal Corporation here?
No, your lordship, it has never been represented.
No, it is not a party in this process.
Not a party also. All right. Page
25.
I appear for the district administration.
Yes, that I am aware. Page, which page did you refer to?
25. And 4/12/2025. My recent order.
And this is in respect of the Kolkata Municipal Corporation. Where do I get that?
Taking into consideration conclusion at page 37.
Yes.
All the aspects the opinion that the applicant illegally constructed boundary wall, tile toilet, storeroom, concrete pathway under Keha Daha Gram Panchayat district. The aforesaid activities are illegal and violate provisions of section 9 of hence the applicant is trying to restore this honorable principle.
No, it's
forwarded.
right. It is where from will it be understood that it is the Kolkata Municipal Corporation has to act? Because this is on the Kheyadeva to Gram Panchayat it is mentioned. Then why will the corporation come over here?
There is separate with corporation also. Either the corporation has to do it if it is a corporation area or the district.
Kheyadeva. Are you for the Kheyadeva to Panchayat? Kheyadeva Gram Panchayat. Page number today a report has been filed. Oh, you are not the Panchayat. You are for the Jila Parishad. Very well. If you are the Jila Parishad, you can always take care of the Panchayat authorities. The block development officer, you please ensure that this order is being acted upon. A copy, please wait. A copy will be given to you. Please check up. Kheyadeva 2 Gram Panchayat is involved. And the next one, page 39.
39 is another construction.
Yes.
This is another construction.
This is also Kheyadeva 2 Panchayat.
This is also. Corporation also I have the lordship of located at not this point of time.
It must be there. It has to be there. And this order is passed only on the 4th of December 2025. So it's a very recent order. Have you served this order upon the... Right. So this order is required to be served upon the... No, not only here, the persons who made the construction, persons responsible, you have to serve. They have? Page 35, 38, I can see copy forwarded. Now, whether it has actually been forwarded or not, you have to check. Please do.
Whether they are aware. Because at that, when the hearing is only going on and when sanction plans are also not produced, since many of the persons who have been given opportunities of hearing, they are full aware of the actual situation which is prevailing at the ground. So I don't think anybody who is participating in hearing and who is being given notice is absolutely in the dark that this is not an illegal.
Nevertheless,
they're very smart.
To avoid the allegation of violation of principle of natural justice, put it up in your official website that these are the plots where no construction is permissible and any construction made thereon will be demolished in accordance with the act itself. So that way, at least you can take care of the principle of natural justice. Thereafter, individual notices you'll certainly give because the act requires a notice of hearing to be given, right? And show me something that you requested the state to provide you some. If it is here, then I can direct the state.
It is here itself, copy forwarded to, there has been, Mr. Chatterjee is in a clear, he will be able to apprise your lordship more clearly than I should have. There is a change in the office of the district magistrate. Some new incumbent is there.
That hardly matters. The office remains.
I will follow it up.
So, whatever is required to be done, because till I see some demolition taking place, not me seeing it, the people seeing it, the people cannot repose faith on the judiciary, on the administration, which is extremely disturbing.
May I only say this, 90%, my report says the 90% of godowns are already demolished over the entire area. 90% of the same has been demolished pursuant to my lord's.
Go down.
No, I have
Go down.
It's very, very easy to comment from behind.
Will never be demolished.
I understand. Go down. How many are there? Nobody knows.
Very easy to comment from behind, big structures have been used.
Maybe. Hardly.
And at last I found this sanction plan
Yeah, show me.
annexed, which is in page number 54, right hand corner. Lordship, this Mauza Jagipota is there and the dark numbers are there. I compare it with the schedule
Page
9.
54.
My lord, page 54. P2,
Yes.
P2 is the sanction plan. Kindly come to the right hand top. Proposed G+2 storage residential apartment block at scheme number such and such under Khatiyan number 17, 18, dark number 37 under Khatiyan number such and such. Now, Lordship, this can be compared with the schedule. I have compared. It is falling, Lordship. I have to recheck it and verify it. I just
Falling within which? The
schedule, Lordship. That I will again verify. I just at a
it
glance I have verified. Schedule 9.
within the wetlands.
Wetland, within not with. There are 3 categories.
Yes.
The portion of that has been identified as the substantially wetland. Others are settlement area, Vastu area.
Under which land does your sanction plan fall?
Lordship, this Vastu area. Lordship.
Check up. Check up.
G+2 is not office of Gram Panchayat.
Yes.
1.1.
Right. How can such a big construct? The panchayat is going on sanctions. Absolutely illegal. It cannot be done. It cannot be done.
That has been done, Lordship, somehow because the authorities.
To be undone.
That has to be undone. But Lordship, here, this is a case of Lordship ECMA Act, Lordship, this was coming in my mind, that this cannot be done in the way it is done under the municipal law. It has to be done, Lordship. Lordship may keep the principle of polluters pay also in mind. The constructor, those who are engaged in the constructions. This is a case, Lordship can apply that doctrine and make them liable to pay.
That is different. That is different. What doctrine to be applied is different. Thing is, let us see whether your structure has been identified. There is a list of.
Yes, so that may I be supplied with those copies. I will identify and come back.
505 so far, 505 constructions has been
identified.
My lord, let those that have been identified not only publishing in the website. I tell your lordship, practically no purchaser goes to the website. It will be published in the website along with a English and Bengali newspaper, the plot numbers and the name of the owners. So these are not within the permissible. You cannot construct. You contact us and separate notice will be given. Otherwise, my lord, this will continue forever, never. And my lord, only
both of us, electricity authority,
also same submission.
Same submissions.
I understand because website nobody. Nobody. Paper publication.
Problem will never be solved, my lord.
All right.
And my lord, no big apartments, nobody, not a single one has till date been identified and demolished. Only small walls.
I'm following.
Yes, yes, this is the court.
Entirely, your lordship. Urban Sabujian, my most.
Only one, my lord.
Why
are you targeting him?
Why you always have that? When we have to choose that, you are now.
There are many.
Many. And now he's going to.
My lord, Mr.
Just
My lord, I am falling within the settlement area, my lord.
Just
record my
wait
submission.
for the maturity of this matter.
have not. My lord, I am
A
falling within urban / rural settlement.
Y'all, today you are coming up with a proposal for SIT. Now it will be it will come from the, authority only. State will also prefer one, because otherwise, see, the corporation is not a party. Corporation is required to be implemented as party over here. The Kolkata, please do. Otherwise, you cannot get hold of this whole thing, right? Please.
My lord, I checked up, my lord. It is there. Urban rural settlement. Filing an additional part because you have made because I feel that you are going to demolish it.
No, if that way you cannot be done. You apprehend that something will happen.
No,
Yes.
this is it's an apprehension in REM, my lord.
Are you coming up with an affidavit or report today?
I have a report.
Please give. Report file.
Handing over one to. I'm handing over one to the petitioner, your lordship.
Please do.
Please receive it. No. Why should I give you? Your lordship.
Whatever reports are submitted may it be circulated among.
Each and every day I pass this order, reports to be circulated.
Pay your lordship.
No, I understand, madam. There may be some difficulty, but if we have not got any report, let us
ventilate the date. I will serve a copy.
The report was not supplied. But to us also not.
Report filed by the EKWMA and the state administration in court today be written with the records. Stop. Let copy of both the reports be circulated to all the parties. Stop. In the event any of the parties do not receive a report, it will be open for the advocate on record to intimate the same to the learned advocate representing EKWMA and the state for circulation of the report. Anybody who doesn't get it, please communicate so that it can be served. At least soft copies provide. Next. It appears that large scale unauthorized constructions have been made over the East Kolkata wetlands in flagrant violation of the act and the rules. Stop. The authority and the state are grappling with the difficulty to get rid of the unauthorized constructions. Stop. Paragraph to make the public aware about the unauthorized constructions made over the wetlands, EKWMA is directed to publish in its official website and also in leading newspapers, both in English and vernacular, clearly disclosing the plot numbers over which constructions are impermissible under the Act. Stop. Any construction made over the plots / dag numbers where construction is not permissible is liable to be demolished. Stop. The authority, the state administration, the municipal authorities are requested to act in tandem to ensure that the provisions of the Act are strictly followed and no unauthorized construction is permissible over the, not permissible, is made over the wetlands. Stop. The service providers, namely the electricity and water service providers are have already been restrained from providing any new connection to any of the premises constructed over the wetlands. Stop. The hearing of this matter stands adjourned till 23rd of February 2026. Stop. The progress report of the authority and the state shall be placed before this court on the adjourned date. Stop. Leave is granted to the advocate on record of the petitioner to implead the Kolkata Municipal Corporation as party respondent in the instant writ petition and serve a copy of the writ petition upon Mr. Shapon Kumar Debnath is the person, isn't it? His name is? Learned advocate who represents the Kolkata Municipal Corporation before this court.
I believe all the copies of the orders, because your lordship has passed so many orders.
Yes, yes. All orders are there in the server. Anybody just clicks will get to see everything.
But your lordship knows better.
People have to upgrade, especially when lawyers are there, they can always help. Right.
My lord, only one submission, my lord.
Yes.
My lord, there is a restriction upon the electricity board as well as the water supply authorities not to give such thing. My lord, registering authority till date, my lord, my client has instruction that my lord, new flats are being constructed, the development agreement are being registered. My lord, there should be an order by the
registering authority.
All the registering authorities.
The registering authorities. Now, this order has to be communicated by the state because here the Registrar of Assurance.
Yes, my lord.
Has
They cannot refuse. Not only Registrar of Assurance, it should be RA as well as DSR and
the authority over there.
Department of Fire.
By the
Isn't
DSR,
it?
ADSR,
Yes. Right, because I remember passing these orders.
There was an order. There was already.
So far, my addition of party application is concerned, my lord.
There was an order.
Page.
There was an order.
My lord, but these are to be communicated to the registering authorities. DSR, ADSR and RA.
24th of
February.
February.
কত টাকা পেয়েছে এটা
That means long back this was passed.
ওইটার পিএমএল হোক
These should be communicated to the respective DSR and ADSR and RA.
Ideally upon IGR. Upon IGR.
The Registrar of Assurance and everybody has been restrained.
IGR has to be communicated.
The Registrar of Assurance and the district registering authorities have already been restrained from registering any structure over the wetlands. Stop. The Inspector General of Registration.
Yes.
Learned advocate for the state respondents is directed to communicate this order to the Inspector General of Registration for onward communication to all the registering authorities not to register any property where construction is being made over the wetlands.
My application
for addition will remain. Served copy, you have not served. An application for addition of party has been filed, Can 7 of 2025. Let copy of the same be served upon the learned advocate representing the petitioner.
Grateful, my lord.
Above 3,000, they will not entitle. That ratio has been followed. But subsequently 2020-23, in terms of this honorable court, the ratio has been increased 3,500 to 9,000. That has not been considered by the authority. This is the memorandum.
28th July 2008.
Yes, that is 2023. It has been increased. That order, because of ROPA 2009, the amount has been increased. So let the authority be consider entitlement 2000. Entitlement of the unmarried physically handicapped by virtue of 2008 circular. This is the circular.
This is in respect of the
unmarried. Yes. But kindly see which the authority has rejected, relying the memo number
28th of July. Are you ready with instructions?
No, Malad. I'm not ready with the instruction, Malad, since this matter was heard long time back. But thereafter, Malad, suddenly it has come up without notice.
Malad, kindly see the notice.
Malad, probably it is my mistake. Malad, may I come back?
Without your instruction, it cannot be heard.
Malad, give me a fortnight's time, Malad, so that I can revert back with a report from your lordship, for your lordships.
I believe that what am I praying? I am praying before lordship. Kindly, Malad, set aside the impugned order. Set aside the impugned order and direct to the authority to reconsider for considering the 2023 circular.
Where is the 23 circular? This is only in respect of unmarried daughters. Then
in case of physical handicap, there is no circular.
Let him say.
Malad, may I come back next week then?
Please come. It is better you file a report.
Yes, Malad. That is the prayer I was seeking to make, Malad.
The petitioner is the physically challenged son of a deceased secondary school teacher. Stop. He seeks family pension. Stop. His prayer stood rejected by the assistant director, comma, pension, comma, provident fund and group insurance by communicating memo dated 19th April 2024. Stop. Reliance has been placed now 2024 relying upon the government order number 378 hyphen SE within bracket B slash 1M hyphen 43, page number 30, please check. 43 slash 2003 dated 28th of July 2008. Stop. According to the petitioner, the aforesaid government order will not be applicable in his case. Stop. Paragraph. Learned advocate. Na tar age prayer has been made to set aside the impugned order of rejection and to remand the matter back to the authority for reconsideration. Stop. Learned advocate for the state respondents is not ready with instruction. Stop. Let a report by the state be prepared and circulated by 22nd December 2025. Fortnight's time is being allowed. Stop. Release the matter for further consideration on 7th January 2026.
Great.
Affidavit of service is taken on record. Take these two back. এই দুটোকে ফেরত দিয়ে দিন। সার্ভিসটা থাকবে আর এটা ফেরত যাবে।
ওটা কোনটা থাকবে? এটার মধ্যে নয় তো? এখান থেকে দিয়ে দিতে
গেল।
এখান থেকে
ফেরত
দিয়ে
যাবে।
Madam, for the state respondent in this matter.
The matter regarding the higher scale of pay. The issue has been settled in terms of the adjournment order. Also, but the petitioner is covered in that. And the petitioner's application has been still pending. It has not been
considered.
Your
Which page?
order.
Which? You have a copy? Let me see.
কোন রিপ্রেজেন্টেশন কোনটা বলছো তুমি?
Page.
কোনটা?
Page 37.
7.
Page 37.
Fifth of February 25 is the date.
Lord, may I, sir?
February 2025.
Lord, may I, sir? Lord, your lordship, kindly see the initial appointment, 2003, page 18. Page 18 is the initial appointment by the School Service Commission. Annex P1.
Yes.
English. Lord, the column, the serial number 6, Roman 6. Selected degree as a English BA honors. At the time of selection, she has not given her MA degree. Then your lordship kindly turn to page 19. Page 19, your lordship kindly see that.
Sir, why don't you consider and reject it if the petitioner is not entitled?
No, that is.
But I am relying upon a circular 155, your lordship also.
Then let the authority be relied and then pass order.
Okay, madam.
Why will this court decide all these things?
There is issue with the senior landed that has been answered by the.
Anyhow, your lordship, as it said, it will be critical.
Before appointment, petitioner has not completed part 1 examination. MA in part.
This is DI, which place?
The Bakura.
Bakura.
Yes. At the bench.
DI পশ্চিম মেদিনীপুর, এটা তো DI পশ্চিম মেদিনীপুর তোমার এটা। No. Now it has to be considered by DI পশ্চিম। When you filed the application, it was DI পশ্চিম মেদিনীপুর।
Then after আপনি সেটা ভালো করে দেখুন, পেজ 37 বাঁকুড়া।
এই অর্ডারটা হবে।
না, উত্তম কান্তি করো।
ও, এই যে এখানে বাঁকুড়া করেই দিয়েছে।
এটা নেবেন,
তাহলে এটাকে ফেরত দিয়ে দিন,
এটা নেবেন।
আর এইটাকে রেখে দিন, একই জিনিস, সেম অর্ডার ডেট। ঠিক আছে তো? ঠিক আছে, ওইটা ফেরত দিয়ে দিন। ইয়েস, ডিসপোজড।
এটা নেন, এটা।
Martin Miller on the last occasion you filed a report
Medication.
whether the money has been credited to the account of the petitioner or not. I have taken the report that it has been successful.
Payment
Successful.
completely. Today I'm on only for interest part, Your Lordship. It's some interest. Since it was active from January, February 2020, Your Lordship. 2020. Almost 6 years.
What, a pension or what?
Salary for the month.
Salary area claim. Why was it kept pending for so many days? Petitioner is Shobita Shutar Mojumdar. The employee has died or what?
No, Your Lordship. She's still working. With the implementation of ROPA 2020, the
What
scale of
is this that you handed over?
Well, this is the payment successful. Payment was made prior.
To? Payment to whom?
Payment to the petitioner, Shobita Shuta, that is serial number 4.
Oh, Shobita Shutar.
Shobita Shutar
Mojumdar is not there.
Yes.
I was thinking why Mojumdar is not there. All right. Then why was it pending from 2020 to 25?
after implementation of ROPA 2019, Your Lordship, there was a pay revision.
Is this the higher scale of pay, the revisional that was kept pending?
Yes.
All right,
Month
please
of
come.
January, only the higher scale was not there, but the February entire amount was not paid.
Learned advocate representing the state respondents produces document in support of the submission that the area claim of the petitioner has been released and released on 19th of November 2025. Stop. The aforesaid submission is admitted by the learned advocate representing the petitioner. Stop. The petitioner seeks interest on account of delayed payment of the arrear claim on account of refixation in terms of ROPA 2019. Stop. It appears that the payment fell due in the year 2020 and the same has been disbursed in favor of the petitioner in November 2025. Stop. As the petitioner received the money after considerable delay, accordingly, the respondents ought to pay interest on account of the same. Stop. Next. The District Inspector of Schools, Secondary Education, Howrah, is directed to calculate payment of interest at the rate of 5% per annum on the revised pay received by the petitioner. On and from the date it fell due till the date of actual payment. Stop. Such interest shall be paid to the petitioner positively by 31st March 2026. Writ petition stands disposed.
So 5% for 5 years will be.
What can be done? Previously it was 7. Now I've reduced it to 5. And it is completely your fault. Not that the petitioner was at fault.
Documents were not there, school did not supply. Thereafter, he came to us.
Why don't you all take steps? Yes. 15.
Lordship, I am appearing for the school authority.
And I am for the private
Led by
respondent.
Shamim Authority.
Mr. Mukherjee is appearing for the petition. Mr. Shobhaji Mukherjee is appearing for the petitioner. So praying for 1 week adjournment, Lordship. Just
why?
Lordship, last occasion direction was upon the state to file the report.
Yes.
Lordship, as per my senior's instruction, that since it is a very important as well as very complex thing, so he wants to do. That's
You can also handle it.
yes, Lordship. But
Then
as
did
per
you
my-
get the report?
No, Lordship. Still
You
not.
didn't get the report. Okay.
2009 matlab selection process of Group B.
আচ্ছা, has the other writ come? আরেকটা writ আসতে বলেছিলাম, where is that? What happened to the other writ?
All other read to
The said writ is still pending disposal? Is it pending disposal? 3619?
According to their statement.
What is your submission? Hey, Shailesh, 3617 2009. Please check.
3617 withdraw হয়েছে।
0016 যেটাতে main
হ্যাঁ,
order
হ্যাঁ,
pass
হ্যাঁ।
করেছিল,
That was withdrawn.
Pending lordship.
That was withdrawn.
17414 that was ultimately withdrawn.
And that was filed by private.
3617 case status is pending, lordship. And this has to be brought together.
That is not necessary. It needs to be. Get a copy দিতে পারো?
Those are differently placed. The petitioner in this case and that petitioner is differently placed.
স্যার আপনি স্টেটে তো একটা কপি জেনে ছোট করে স্যারকে বল তাহলে তো কামাই যাবে।
Please come. Report of the District Inspector of Schools, Secondary Education, Hooghly. Filed in court today. Signed on করে দেবেন। Signed on 8th December 2025. Filed in court. Be written with the records. Let a copy of the same be handed over. আচ্ছা, তাহলে লেটে তুলে দিন। Copy of the same has been served upon the learned advocate representing the petitioner in court today. Stop. Learned advocate for the petitioner seeks time to revert with instruction. Next. It appears that WPA 3617 of 2009. Is it your petition? Who is the petitioner?
Lordship.
Other person.
Lordship,
Lordship, it is
the
filed by
writ petition which is withdrawn, that is a particular, the writ petition of the respondent itself. Others are still pending.
No, no. There was another
Petitioner is
petition that was
Vikas
That is also
Chandra
withdrawn.
Mondal,
But
isn't it?
analogous matters are there.
Huh? In connection with the
revisionist.
not in connection, in relation to the instant matter is pending consideration. Stop. Let WPA 3617 of 2009 be listed along with this matter. Stop. Let notice be served upon the learned advocate representing the petitioner in WPA 3617 of 2009. Stop. List the matter for further consideration on 5th January 2025. Monthly list. Next. You take instruction with the other matter also. Why is it pending? All right. ওটাও লিখে দিন তো, learned advocate for the state shall take instruction with regard to the ওই 2009 writ petition. Yes.
16. Item number 16. 16. Taposh Kumar Mondal. Lord, kindly come to page 18.
May hear the report. Last occasion, you should direct the state to file a state pattern.
Give a copy to him so that he gets to know what is there.
I was restrained on 10% ground, my lord.
What is the staff strength now? Road strength is
My lord, kindly come to page 82 for once. That is the status. Actual
Already
status.
6 permanent teachers out of 40 sanctioned posts and 5 para teachers. And the teacher ratio of the year 294:1, my lord.
Cannot
yes.
That is a report. আমি কি বলবো ভাই? The report আছে আমি তাই।
My lord, page 82 at that point of time, I was restrained on the ground. School allowed me to take transfer on 10% ground. School allowed me. Now DI returned in
Page 80.
82.
82.
82, my lord. Kindly see my application. On 6th of July 2022, I made application. School sends it to the DI with the observation. School has no any objection at if he is transferred. Then DI returns it on the ground due to out of 10%. But my lord, school had allowed. And my lord, the lordship is aware of the notification of 10 AC, where the 10% of ground is no more a bar for allowing transfer.
No, no, video.
There are two teachers in Bengali subject in normal section, including the petitioner.
Yes.
It's 29:1. So it is within the roll strength. It's all right. Please come. Learned advocate for the state respondents has obtained the roll strength of the school, wherefrom it appears that the pupil teacher ratio is 294:1. Stop. There are two teachers in Bengali subject in the regular section, including the petitioner. Stop. This school is a bilingual school within bracket Bengali and Urdu medium.
I was appointed for Bengali only. This is a combined number they have given of Bengali and Urdu both. I'm for only Bengali, that will appear from page 26. So they cannot take the numbers of Urdu medium also. Subject to correction, possibly, my lord, both numbers have been taken together. Otherwise, 294:1 is something.
এটা বলেছে আমাকে ভাই, এটা বলেছে আমি তোমায় সেটা
29:1.
29 is
294:1 it is.
Yeah, I can see that.
Cannot be.
It cannot be 294:1. I
Possibly
couldn't
including
understand.
Urdu. Possibly including Urdu medium, it has come to this. But I was appointed for Bengali medium.
6 permanent teachers.
Whatever.
বলেছি সেটা
The
8%
petitioner's application seeking transfer, though approved by the school, to rejected by the district inspector of schools by holding the same that the petitioner does not fall within the 10% strength of teachers that may be transferred. Step paragraph. As more than 3 years have elapsed from the date of rejection of the petitioner's prayer for transfer. Accordingly, the matter is remanded back to the district inspector of schools to reconsider whether the petitioner's prayer for transfer can be accepted, relying on the present scenario.
In respect of memo 10 AC, page 73, let that be taken into consideration. Page 73 is the notification regarding 10%. 3rd January 2022.
The district inspector of schools shall take into consideration the notification being number 10-SE, page number 73. Please copy this. Dated 3rd January 2022 at the time of consideration of the petitioner's prayer for transfer. Steps shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Writ petition stands disposed of.
Grateful, my lord. Much obliged to your lordship.
I'm grateful to you.
But I'm appealing
Just
on
now
the
I
behalf of
received
state,
the
my lord.
document
Last
from the state.
occasion-
May I come back? May I come back? I just received the document from the state.
You received, all right, give.
Just received.
The
What is
last
this?
occasion, your lordship, like, there is a order to file the report. COMH Malda is, do not recommend the transfer of the candidate petitioner because it is not considered the very good ground. Illness is
Alright.
not serious.
All right.
My lord, I do not know when this document was page 5. 5 is the observation. Page 5, I do not know at what time this was obtained.
No, whatever it is, the report of the DI is 5th of May 2025. So it's pretty recent.
That's what I'm saying. My
Right.
case was different. My kindly come to page 96. Page 96 mine of 2022. And there is a wrong observation that I had challenged when it was sent to DI. Kindly see the top right hand side. It's a medical ground transfer. She is a single geography teacher, no student. Single subject teacher is no ground as per rule 62E. The lordship has considered that in case of medical ground transfer, student teacher ratio will not be a bar as per rule 62E. Now this is a wrong observation which I challenged. Now my lord, next page, medical board was formed to conduct the medical verification. Since thereafter the portal was under suspension, matter was not proceeded with. Then I came before this honorable court. Now this report is of, I do not know my lord whether it's a present or that
It is
point of time.
present or
Present, no medical verification has been conducted of mine. It is of 2022, last it was pending. My learned friend is saying it is present, then there is no present
as
medical
per the
verification.
instruction I am saying.
No, I'm
So no, when was this medical examination done?
2022 possible. I do not know whether it is how it has come based on that report or today's.
Where is the report?
My lord,
Image certificate. Where is the medical report? When was the medical examination conducted? Please come. A report in the form of affidavit has been prepared by the DI. Secondary Education, Malda. From the said report, it appears that the petitioner's prayer for transfer has not been recommended by the Chief Medical Officer of Health, Malda. Stop. There is no mention of the date as to when the medical examination of the petitioner was conducted. Stop. The learned advocate for the petitioner submits that the petitioner has not been medically tested recently and the last medical examination took place in the year 2022. 22, is it 22?
My application?
Medical examination?
Yes, page 97. It was directed to be conducted by the letter dated 21st of September 2022. So it was in 2022.
2022. Stop. The DI is directed to forward the copy of the CMOH before the court, relying on which the petitioner passed his order of recommendation. Now, relying on which the DI refused to recommend the prayer for transfer of the petitioner. Yes, sir. Released on 5th of January.
Grateful to Lordship.
For the petitioner, I'm praying for 1 day accommodation, my lord.
1 day accommodation?
I'm praying for 3 days accommodation.
3
And the lapse of on our part also. An oversight, two matters 18 and 19, they were taken up one after other on the last occasion on 26th when your ladyship was pleased to pass orders to file report and circulate. The problem is that my on record is same for both the matters. Due to inadvertence, he has prepared it for 19, not prepared it for 18.
All right, please come. On the prayer of the learned advocate representing the state respondents, time to file the report by way of affidavit is extended till next Monday, 15th. Stop. Released 22nd.
My lord, state and the SSC, we will also
You
file a
also?
report. Yes.
You'll be able to do it within a week?
Yes, yes.
All right, same. Tahale adjournment state and SSC. Yes, next.
19 alada.
19 alada.
I appear for the petitioner.
Yes.
The petitioner is praying for age relaxation pursuant to the orders passed by the Honorable Supreme Court of India.
All right.
in respect of my lord RCI certificates. Petitioner was working under Sarva Shiksha Mission as a special education, but my lord, in the present selection process, my lord, petitioner could not fill up the form because age relaxation was not granted to him. My lord, last occasion, your lordship told the commission to file an affidavit in report in this regard.
The report is ready. The copy, however, I am handing it over to my learned friend here and now.
And the dates for filling the applications are over?
That is to be seen.
Yes, my lord, it is over.
It's over.
But the writ petition was filed
Yes, yes,
within time.
September 24th.
The writ petition
September
was
24.
the writ petition was affirmed on 16 September 2025. So it was way before.
No, not way before, margin.
Seek this benefit.
All right.
But
Age relaxation, he cannot seek. All right.
Reading one sentence of the whole order in isolation, we want to press a case that the order shall not be read in isolation. The whole order should be read. I can place the order before your ladyship. There is one sentence that the petitioner had relied on. It is on page 79. Your ladyship may kindly recall that there was a litigation before the Honorable Supreme Court. There were directions, my lord, to appoint special educators or teachers in schools for children in special need. Thereafter, there was another order also passed in March 2025. Page 79. Further, in case of persons who was already working and teaching for the last many years, the screening committee shall also be authorized to consider relaxation of the age limit in appropriate cases. This was being relied upon by the petitioner, saying that I was working. It is an admitted case that he had left his job in December 2021.
Lord, I have left my job, my lord, in December 2021.
Yes, December 2021.
My lord, Supreme
was
Court does
not-
not say
Yes,
that, whether I leave it on.
May I please?
Those persons, those who were working, my lord,
Did you go through the report once and then come back? Report in the form of affidavit filed by the Assistant Secretary. Filed by the representative of the School Education Department, Government of West Bengal. In court today is taken on record. Stop. Let copy of the same be served upon the learned advocate representing the petitioner. Stop. Do you intend to file an objection? Exception?
not take much time.
Will it be required? I
It will
don't
not be
think.
required. It is a pure question.
It is on
It's
the
a question of
the
law.
Interpretation of the
Right.
Supreme Court's order.
Cannot be done. When?
This week, any day.
This
Otherwise, my lord, they will give
possible.
appointments.
It will not be possible.
Because I have come before the
15th.
court on.
Let it appear on 15th. Let it see what can be done. Yes. Will the commission rely on the report of the state?
Yes, yes, yes.
We'll give you a copy, sir, also.
কবে রাখলো এটা? Monday?
15th. 15th.
No, 20.
20, my lord, I am for the petitioner.
Yes.
For the I have responded.
I have begged apology, my lord. On last occasion, I have submitted wrongly. The overdrawn amount was deposited through TR challan, but instead of TR challan, it was deducted from the gratuity benefit, my lord. Is that page number 15 in PPO, my lord? I have corrected your lordship's order.
Yes. What is your submission?
Actually, my lord, overdrawn, my lord. That is, my lord. My lord instructed my back that the order was issued, my lord, after his retirement, my lord.
After his retirement. The petitioner is a retired teacher of a secondary school. Stop. He retired on attaining his normal age of superannuation on 31st March 2025. Pension payment order was issued in his favor on 12th March 2025, mentioning that a sum of rupees 1,22, 432 was being deducted on account of overdrawn payment. Stop. The petitioner is aggrieved by the same. Stop. It is submitted that the petitioner was never made aware of any overdrawn payment during his service tenure. Stop. The petitioner, for the first time, came to learn about the overdrawn payment after the same was reflected in his pension payment order. You had not known anything. This is your case.
This is my case.
Directly from the PPO, it has been deducted. The money has been deducted directly from the gratuity amount. That has been paid to the petitioner. Stop. According to the petitioner, the same is impermissible in law. Stop. Prayer has been made to refund the money deducted from the gratuity amount of the petitioner. Acha. Learned advocate for the state respondents admits that the that না এটা কেটে দিন এটা করুন 5 7 8 and 9. All right, disposed.
Much obliged.
I am for the petitioner.
But I am appearing for the 4 and 5.
Last order. Passed by your lordships, that is on 26th November.
Yes.
There's a direction upon the, my lord, learned counsel appearing for the district inspector of school to take instruction.
Because I'm from the state respondent, my senior couldn't come to the court, so I'm just paying for not today.
Your senior has not come to the court. Who is your senior?
Said Najmul Hussain from state respondent.
The matter is there in the list and he has not come to court.
I don't know. He told me that to tell.
Very strange. Somebody is being made to work. What is your submission? The school?
From the school, my submission is that, my lord, it is non-approved post.
Yes.
There is no fund in the school at present. My lord, getting salary, but regarding increment, my lord, the school fund, from the school fund it is giving.
That is the admitted part from their.
So, my lord, approval is.
They have admitted that, my lord, we are working without pay. School
Not
has no
without
problem.
pay. Less salary.
Less salary.
Right.
Less salary, and from April 2023, no salary has been paid.
More than 2 years, no salary. Why are you working? Why don't you find out some other place to work where you can get at least something?
Oh no, we are aged about, kindly see, my lord. Aged about
55
years.
What can be done? You are working in an unapproved post. You will not get any pensionary benefit. Nothing of this
My
sort.
approval, the post,
61.
the issue, my lord, is pending before this honorable court.
Then get that resolved.
But my lord, my monthly salary, my lord, should be disbursed.
Provided. provided the post is an approved one and provided the school has some fund. He says that the school doesn't have fund. How much is the, how many students are there?
Can you see?
Page 60, 61, 62, 63, all for the state.
Get
Why-
salary, my lord, page 60.
Why the fund is not available in the school? You obtain DA from the government, it is said. It's a DA getting school.
DA getting
Not
school.
getting now.
Why?
Well, they have a stop.
State government has stopped giving DA. For what reason?
That is the fund
How many students are there in your school? And how many teachers are there? Please come.
that I should take this.
Accommodation has been sought for on behalf of the learned advocate representing the state respondents. Stop paragraph. Learned advocate representing the petitioners submits that the petitioners are not getting their salary.
Getting less salary.
You say not getting salary.
Since 2011 to 2023, March 2023, we got
Less.
less.
From
And since
23
2023, it was paid in irregular manner.
23
Irregular manner, and that is
ঠিক আছে,
they're getting.
কি বললাম?
Absolutely.
Page 61 onward.
এটা একটু নেবেন তো affidavit size.
Since are not getting regular salary since March,
April 2023.
April 2023. ঠিক আছে? Prior thereto, from 2011 till March 2023, the petitioners were paid salary at a reduced rate.
Yes.
Stop. The subject school receives dearness allowance from the state government.
Yes.
Stop. Prayer has been made to direct the school to pay their regular salary. Paragraph. Learned advocate representing the school submits that the petitioners are working in unapproved posts. Stop. The school does not have the fund to pay the entire salary of the petitioners. Stop. The state government has stopped providing DNS allowance to the school. Full stop now. For which there is acute fund crunch in the school. Stop. The school admits grant of irregular payment to the petitioners. Paragraph. Learned advocate, no. The district inspector of schools is directed to file a report by way of affidavit disclosing the present status of the school. Stop. The number of students enrolled therein and the number of approved teachers. Stop. The report shall specify whether DNS allowance is being provided to the school or not. Stop. If the DNS allowance has been stopped being paid, comma, the reason therefore, stop. The report shall also disclose the number of unapproved teachers who are teaching in the said school and their mode of payment. Stop. Next. The school management is directed to cooperate with the district inspector of schools for preparation of the report as mentioned herein above. Stop. A copy of the report shall be circulated by 9th January. Release the matter on 19th of January 2026.
My lord, in item number 22, I am for the petitioner led by Mr. Fidel Samim. He is engaged before the court number 14.
This is
And he
identical
granted
of
short
Lubana
trial
Miller. This
It is fixed tomorrow.
Lubana is fixed tomorrow.
I'll keep it tomorrow.
Yes, yes.
Not
This is
today.
rule challenge.
So let's
23 আমাদের কে বলছে?
rule challenge.
বলো।
Well, 23, my lord, the 10 months teaching experience, my lord, fixed to receive on my lord tomorrow.
Today.
Tomorrow, my lord.
Tomorrow. You want it tomorrow? I'll place it.
Well, this is with regard to that the experience gained in one category cannot be.
Yes.
My lord,
That was not the issue on those in those
but
writ
this is the
petitions.
one of
This
the-
is the issue which you have filed in this one.
Yes, my lord, that is one of the 6 can are there, my lord. The can has been disposed of. They have added the all cans, my lord, but your lordship is direct to file the affidavit. That is the one affidavit has been filed till today. My lord, the counsel are there, my lord.
Anybody for the applicants over here?
No, there is no such application. Mr. Learned Senior, Mr. Dhod is appearing in this matter. And last occasion, Learned Senior Menoga Gurusami was also appeared in this matter.
Well, one submission was argued that
Yes, yes. I have concluded my.
Anybody teaching in the 9-10 section will have the
Yes, yes, yes.
benefit of teaching in the 11-12 section.
Teaching experience of the lower curricular calculated be decided in the upper post. 9-10 teachers, one of the experience, teaching experience.
All right, then I'll club it up with that matter only. It will be only not today.
Yes.
Tomorrow it will be taken up.
Miller. 24টা কি?
Number 24, for the petitioner, my lord. That petitioner here in that teachers of petitioner is a teacher of private school. My lord, is claiming she is claiming, my lord, the 10 marks teaching experience. Because, my lord, according to me, there is a discrimination. The private school teachers will not get, the government school teacher will get. That's a discrimination, sub-classification. My lord, just may I indicate that
State submission, private schools and the government schools.
এই নামটা লিখে দিন।
Discrimination is the point taken.
Yes, yes. My lord, as we have also submitted, my lord, in other matters also, my lord, these are teachers belonging to private schools. My lord, we have made it categorically clear that we are going to consider those of the government schools. Now, my lord, they are not of the same class. Why we say that? There has to be a rationale behind it. But if we start entertaining teachers of private schools, we will not be able to verify whether actually this experience is there or not. As far as government schools are concerned, my lord, it is verifiable. But as far as private schools are concerned, my lord, we may end up with a situation where people come with the experience, but actually not having that experience at all. Merely by obtaining a certificate from the head of the institution, by saying that they have so and so teaching experience, my lord, it is not verifiable at all as far as the private schools are concerned, which is verifiable as far as the government schools are concerned.
Why the private schools will be receiving salary and everything? You can check up their records to see. You can get records from the school and see.
No, my lord, it is that kind of verification, my lord, will lead to my lord, a huge complication in the entire recruitment system. My lord, the parameters as far as the state aided, my lord, what we have given the teaching experience for, my lord, and the parameters for the private schools, my lord, are not the same at all. And it is not that there is no intelligible differential between the two. There's definitely, my lord, two different classes, my lord.
experience.
হ্যাঁ দেবে ও আছে नहीं पका चलो
That means they have not been able to fill up their forms also.
No, no, we have filled up our form. We have filled up our forms. We are not been called for.
Marks you are
Yes,
getting.
yes, yes, yes.
That is why we're not called for it.
That is why we were not called for verification, my lord. Verification is going.
You could reach up to that level. The cutoff.
My lord, if 10 marks, my lord, if we get, then my lord, we will go through.
Without the 10 marks, you cannot reach
No, no,
that
no,
level.
no, no. But they are adding it. They are adding the academic and. My lord, and one more point, my lord, I want to submit, my lord. These private schools, all private schools are recognized by the government of West Bengal. Even ICSC and CBSC schools, my lord, specific no objection is required. I have handed over last time, my lord, pursuant to the direction of a coordinate bench. All schools, those who are recognized, my lord, has been listed by the school education department. So this argument, my lord, the private schools are having a different class, my lord, cannot be said, my lord, particularly on the ground of experience, because private school teachers are having experience, government school teachers are also having experience, teaching experience, and the object of the rules, if teaching experience is required, then my lord, the best teachers would be allowed for the government schools. Even we are having experience for a long period of time.
But this long period is fragmented. Your lordship will note that.
This is fragmented, my lord, but still some marks we will get. If someone teaches for 1 year, he will get 2 marks. If someone teaches for more than 10 years, he will get the full 10 marks. But there is one more matter also. I will give the number.
My matter is there on same point.
Last attack.
না না একসাথে করো না প্রত্যেকটা আলাদা আলাদা
আরে প্রাইভেট
তোমারটা তো
না
এভরি পিটিশনার হ্যাজ
আরেকটা আছে সেটাতে ফ্র্যাগমেন্টেড
আগে ফ্র্যাগমেন্টের
Fragmented করে নি?
না না একসাথে Lord, in this matter the person concerned has fragment.
এই ডিভিশন বেঞ্চের জায়গাটা
Yes, state anything else?
Yes, Malad, I wanted to add that at page 22, as far as this petitioner is concerned, the petitioner is having a fragmented service, Malad, and it is not continuous. Even in that case, Malad, assuming as if we at all get into the discussion whether their experience should be considered or not, this petitioner with the fragmented service will not come within the bracket of substantive post at all.
Well, I have challenged that part.
Wait.
Ad hoc teacher kindly sees it not even continuous from time to time. From 2019, they have been appointed in tranches as per requirement, it appears.
Yes.
Kindly,
School.
yes, kindly takes page 22. First, they were appointed from April to March April 19 to March 2020. Then after 1.5 years from August 2021 to March 2022. Then after 2 months from May 2022 to March 2023. Then after 4 months from July 2023 to 31st of March 2024.
My lord, this 2019.
Then definitely not thereafter, because this is issued in July. So then it would have said
My
that
lord,
July
kindly-
2024
Kindly visualize,
till
they cannot
date.
say it fragmented. 19 to 2020, my lord, 31st March, it was there. My lord, thereafter 21st August, that period, COVID period was there. 31st March 2022, then 9th May 2022 to 31st March 2023. And then 33rd July 23rd.
COVID has not caused break-in
But
service of
even-
other teachers.
31st March 22, the second entry, and then
9th May 2022. My lord,
that's April was not there.
April was not there because of the new session, but still,
So that way you cannot.
my lord, kindly visualize.
Teachers according to
My
this
lord, suppose
session.
my lord, private school teachers, my lord, 5 years I am in one school, 3 years I am in another school. The question is of my lord teaching experience.
Here you are in one school only.
Yeah, one school only, but the question is of teaching experience. Now, if it comes to my lord, then I will not get full marks. I will get 2 marks. 2 marks in the selection process would be huge. And my lord, there are other matters, my lord, where the teachers are permanent teachers in the private school.
All right, now this is not one of those permanent teachers. This is
It is admittedly, my lord, ad hoc basis. Ad hoc basis, but the question is, my lord, the experience. We want the marks of experience. I will get less if it is not continuous. If it is 1 year or 2 years, per year they are giving 2 marks. So, my lord, if it is coming to 2 years, then it will be going to 4 marks.
all right. Yes.
And the rule does not say anything about continuous or.
No, but the rule says about substantive post. There
That
some
is
meaning has
understood.
to be given to substantive post.
Difficulty is the rule doesn't define substantive.
Right, but it has to be understood in the uh, law which is there, law which has been interpreted. Now, Malar, substantive post has to be understood under certain parameters at least. Number one is that there must be a sanction post. Number two, there must be a regular mode of recruitment. Definitely, Malar, this number two cannot be satisfied by the petitioner who are working for 1 year, then left out for no authority after taking a regular mode of recruitment will take a teacher like this. Anyway, it's an assumption, but it's a assumption which cannot be thrown into the dustbin. Number three, continuous length of service. At least these three basic things has to be read into a substantive post. And I'm sure in one of the matters, Mr. Bush has already addressed your lordship on this question that what should be meant by substantive post. But these three minimum foundations must be there in a substantive post.
All right. Yes.
But I'm just adding on to what Mr. Bandopadhyay is saying. My lord, a teacher in ad hoc basis appointment cannot share the same or equivalent workload that of a full-time or a whole-time teacher in any school. So, in under no circumstances, the argument that the teaching experience should count will matter.
If you speak about workload, these teachers take maximum workload, and those on regular basis, they just somehow save their service. This is the thing.
But so far as the rules are concerned, my lord, the permanent teachers are supposed to take a certain workload, my lord, which has to be different from them.
My lord, one High Court's view, Himachal Pradesh, my lord, kindly see paragraph 17. The way it has been dealt, necessary factor if any awarding marks on the basis of teaching experience issued by the competent authority experience. Once on account of the petitioners having worked in the school in question, he obtained teaching experience coupled with the fact that marks, if any, in terms of the scheme formulated by the selection committee were to be awarded on the basis of teaching experience, if any, possessed by the candidate concerned. Question with regard to the appointment of the petitioner in a school without permission of the government. Substantive means they are trying to say that they were having permission from the government. But this is not required at all. May not be of such relevance. Moreover, in the case in hand, certificate has been issued by the principal of the government senior secondary school, Guma, who is unequivocal terms, but that was issued from a government school. But the fact remains, my lord, the question is experience. Whether it is private, whether it is government, the question is experience. So that is why, my lord, I have challenged the rule in this regard also.
And my lord, only to add on, Jawahar Navodaya Vidyalaya, my lord, in matters, my lord has already rejected people who have fragmented sons. Have rejected the writ petitions.
No, we are not claiming appointment. We are just claiming the 10 marks, only
Lord,
experience.
rejected on the point that they do not have the right to approach.
My lord, that means, my lord, the state must say that the teachers of a private school will not have experience. They are not recognized.
They may have experience, they may not have experience. They are not within the note which is appended to Schedule 2.
That means experience is of a private school is not recognized by the state.
We are not
recognized
for the purpose of Rule 2025. We are not recognizing it for giving 10 marks. Government and government-aided schools in a substantive post, permanent or contractual.
It is a substantive post,
and my lord, I being the
contractual
I being the employer, my lord, I have the elbow room to fix the eligibility criteria. If it is not so arbitrary that it shocks the conscience.
They are allowing contractual. That means ad hoc basis will also be allowed.
Ad hoc and contractual are not same.
Government schools and private schools.
Ad hoc and contractual are not same.
For private school, my lord, it is same because the private school, the managing committee is the authority.
Please come. The petitioners, petitioner participated in the second SLST within bracket 80, 2025. Stop. He claims marks on account of prior teaching experience.
अगला वो है अगला
The
इधर 24
rules
25
pursuant to which the recruitment process is being conducted is also under challenge. Stop. Paragraph. According to the respondents, the petitioner is not serving in any substantive post. Stop. She is an ad hoc teacher serving on a fragmented manner in the school. Stop. There is no method to verify the certificate issued by the head of the institution
ये है मेरे
in
पास
favor of a teacher.
संगीता संगीता था मेरे पास
Whether marks on account of prior teaching experience can be provided to the teachers of private schools is to be adjudicated. Stop. When are the other matters coming? 10th.
याद है तुम्हें I'll check and the date.
Released on 10th because the rule is challenged in the 10th.
The rule is not challenged. Yes, yes, yes.
Yeah,
There is-
only that
Yes,
that
yes, my
provides so
correct.
the note
Only
they are
that part
challenged.
is challenged.
That part is
There be
challenged.
there be
Yes.
Government school.
Yes.
ঠিক আছে, released on 10th. এটা রেখে দিন এর সাথে।
Well, this matter is also same, my lord, private school, but they are working as permanent teachers.
Which one?
Well, I am writing the number, well, item number 150 of daily lease dated 5/12, WPA 27-325-2025, same,
Give the number to them also. It will be added up in the second SLST
on 10th, with this matter only.
in the bundle of second SLST.
Well, kindly pass an order to that effect. If
No order is required. It will be upgraded.
Teacher without forgetting.
Yes.
Well, item number 25 relates to part-time teacher claiming 10 marks, my lord. It can be posted, my lord.
Yes, 10th.
This we have taken instructions that they are not appointed against sanctioned posts.
But we have
Because in both the schools, very well, if your lordship is desirous of taking it on a different date,
10th. Actually, various provisions of the rules are under challenge.
and Malad, so many categories have happened, Malad, that returnable dates we are getting confused.
Various issues.
Various issues, various. And all possible issues that can be challenged in a selection.
No, no, pay gaji. Shungi to
My lord, only one thing is only one request, my
27.
lord, since your lordship is basically
27.
hearing two matters, my lord. One of Mr. Shamim's and another is, my lord, that Shishir Ghosh, whether who can get those marks and in what stage. These are the basically
Stages.
at stage, my lord. These are the two basic lead matters.
কোনটা কি বলছো?
Comments to your lordship has heard it extensively. Well, can it be made tomorrow hard in part? Because আরে ওই দুটো ম্যাটার মেইনলি শুনছে শিশির ঘোষ আর আরেকটা এটা শুনতেছেন লুবানা পার্ট না আমি বলছি আদারওয়াইজ মাই লর্ড ইট উইল
Is there any possibility?
No, my
I
lord.
do not know.
After vacation, normally, my lord. After vacation, again, my lord, since it's a
But then this matter has been heard
yes.
If it is heard substantially by
My
the
lord, you have
bench,
to approach, you have to reassign.
No, but is it changing? I do not know. Why is this apprehension?
Might change because normally, my lord, after
nobody
the
knows.
vacation,
Nobody knows.
nobody.
This is
The matter will
hard. It is
the matter will
substantial.
appear tomorrow. We'll have our leaders to make the necessary submissions.
I think they should not oppose. They are.
Assuming
It is not
treated-
there today.
Assuming that it is treated heard in part, but the moment the bench changes, the heard in part goes.
No, my lord. There is a
Cannot remain.
subsequent notification of the.
What does it say? It will carry.
Supreme Court has directed to
Yes.
complete.
The matter is coming up tomorrow. My learned friends can hold on to one day at least.
We are making.
No, we'll.
all parties.
Yeah, we'll
Understand a mutual understanding that it has been heard in part.
Yes.
Let us see what happens.
My lord.
And tomorrow we'll have advantage of our respective leaders also to make the appropriate submissions.
Yes. Rekha Shekhar. Rita Shekhar. What is it?
The boss is appearing for the
appearing
for the petition. Engaged in court number 6 for a matter.
General to?
General to EWS. Application page 52.
For accommodation for the day.
For a day? No, not the
Transfer from general category to EWS category.
EWS. All right, I'll take it up tomorrow.
Yes, sir.
But they have failed to update in the meantime. Same as I think the matter which was extensively heard in the morning.
Yes, 26.
कोई औरत है?
27. Not
27 is my matter, millet. Here also, millet, I have challenged the millet rule. And alternative prayer is that those who are working in the private school millet should be given millet benefit of 10 marks. Primary challenge is millet, the challenge is rules. Challenge the rules because it discriminates millet. Which the act,
it discriminates between the government
private and
the private,
which is not permissible. Even if your lordships can look to them millet, the act under which the rules have been framed millet, it will be possibly millet clear. I am not armed with millet the national educational policy, but I'll be placing later millet. But today millet, if your lordships kindly look to them millet, the act.
No, the act is not here. Maybe it is here. Headmaster's manual. আচ্ছা যেটা আছে সেটা দিন. Are you relying on the amendment?
No. Parent Act. 353. Right.
Tell me one thing, why did you file the writ petition in November when you knew that the rule came into effect from 29th of May 2025?
That rule doesn't that in practice they have adopted that we will allow only the in fact, but one of the petitioner has been awarded with marks.
Being a private school
Being a private.
teacher.
That's the
in the verification stage it will go.
Many have been
even
awarded.
today we do not know what will happen.
I understand. Many has been awarded marks, and then later on those marks were deducted.
That's why they are acting in an arbitrary manner. That's my point. How come they can once award marks and then subsequently take it away from me?
Always there.
Therefore, they are not sure about this the proposition of law.
But on the other hand, the petitioner, despite wanting a job of
And if you
teacher,
kindly
filled
state
up,
way,
experience knowing that she is not eligible, or she perhaps chose not to read.
And based on my information, you have awarded me.
Based on the false information.
Yes.
But section 15 first.
Section 15.
I am placing this section, keeping it in mind that this act was introduced to establish School Service Commission Act for recruitment to certain schools. Now, section 15 is the exclusionary clause. Act not to apply in relation to certain schools. the provisions of this act shall not apply to the minority institution, religion and language, then school under any trust established and administered by a minority, whether based on religion or language. C, school not in receipt of financial assistance from government. This private school. School in receipt of financial assistance from the state government towards DNS allowances only of teachers of such schools and government schools. Now, these are the schools where the School Service Commission will not recruit. Now, kindly take some definition of teachers. Definition of school, clause N, and then teachers.
Yes.
School means a recognized non-government aided secondary school or education institution or part or department of such school or institution imparting instruction in secondary education. So these are the schools where they will recruit. But in all places, when the question of recruitment comes, they have made it specific. Now, kindly comes to definition of teacher. Clause P. Teachers means an assistant teacher or any other person holding a teaching post of a school and recognized as such by the board or council. Mr. Bikram Banerjee was arguing. As the case may be, and include headmaster or the headmistress, but shall not include the assistant headmaster, assistant headmistress, or teachers holding a post against short-term vacancy caused by deputation, leave or lien. The last part also made clear that these are not included, and all those who are working in a school recognized by board or council are teachers. Therefore, for the purpose of this act, all are teachers who are recognized by this board and nothing else. Therefore, they cannot mechanically distinguish from private school to aided schools. But in fact, they have recognized all schools in their rules relating to recruitment of headmaster and headmistress. If you kindly look to this is rules of 2016, I'll hand over my hard copy.
No, you tell me what it is.
The schedule refers to
Schedule of
2016 rules for recruitment to the post of headmaster and headmistress.
All right.
Then clause 1 is the essential qualification. That marks and qualifications there. And clause 2, 10 years continuous teaching experience on the last date of submission of application in approved service in a higher secondary school, high school, junior high school recognized by Board of Council, West Bengal Council of Higher Secondary Education and West Bengal Board of Secondary Education. Therefore, they have not ever mentioned that only teaching experience of private aided school will be considered. Even for the post of headmaster, experience has been mentioned with reference to recognition.
This is 2016 recruitment rules. Which provision did you?
Schedule 1.
Schedule 1.
In reference to rule 3 and 4.
All right.
Yes. Now, if you kindly looks to the present rules, at page 65. Here, they consciously made a departure from their previous stand. without amending the original act, parent act.
Yes.
Lad, schedule 2, after the box, prior teaching experience of 10 marks at secondary level in a government aided, government sponsored, calculated on the basis of 2 marks for each year of service in a substantive post. Now, Mulat, kindly see, so far, Mulat, recruitment to a teacher of a teacher in a school is concerned. If you actually kindly look to section 15, government school has been excluded. For the purpose of teaching experience, in the new rules, they have recognized government school. Now, Mulat, this exclusion of private school, first my submission is beyond the scope of the Parent Act. Therefore, by way of rules, they cannot go beyond the Parent Act. And second,
Yes.
there is no rational nexus with the object to be achieved.
Yes.
And third is, Mulat, this is Mulat classification between the same category of teachers. Because Mulat, if you actually look to Mulat NCTE Act, copy nahi.
What is this? NCT? Yeah. Yes.
Blood, if you kindly take some blood definition clause, clause K small a, section 2.
Yes.
School means any recognized school imparting pre-primary, primary, upper primary, secondary, senior secondary education, or a college imparting senior secondary education, and includes.
It's not there. Section 2.
Section 2 K small a.
No, A small a is not here. This is the 93 Act.
93 Act, possibly this was amended.
Amended, yes. The amended provision must be here.
2012 amendment was made.
Must be here later on. Please find out from here which one he is referring to.
আগের দিন বলে দিয়েছে তারপরও বই আছে
Yes.
2012 1st June 2012. But may I read, Millet? School, Millet, clause 1 is a school established, owned and controlled by central government or state government or local authority. Clause 2 is school receiving aid or grants to meet whole or part of its expenses from central government or state government or local authority. And clause 3 is important. School not receiving any aid or grants to meet whole or part of its expenses from the central government, state government or local authority. Therefore, all schools are included in the definition of school.
Yes.
Therefore, anybody who is working in any of these school blood are similarly situated.
Yes.
Now, if you let's kindly look to Right to Education Act. Again, Rule 2, Section 2N. school means any recognized school imparting elementary education and includes, in fact, the same provision as in NCT and clause 4 an unaided school not receiving any kind of aid or grants to meet its expenses from appropriate government or local authority. The argument that substantive post means the post sanctioned by government is not enough to include all schools, all posts. Rather, the interpretation should be the act mandates pupil-teacher ratio vis-a-vis the obligation of the state. And whoever working in terms of that ratio are working in a substantive post.
How do the commission verify?
All schools are recognized by the board. Commission comes later. It is recognized by the state and its instrumentalities under a particular act. Therefore, and in terms of, and they are bound to follow the NCTE Act vis-a-vis the standard of education. And these central statutes under these central statutes, the state is under obligation to maintain pupil-teacher ratio and in fact the scale of pay of the teachers. That there is settled law by the Supreme Court, which is not done here. Now, whoever these private schools are in fact discharging the obligation of the state, and for that reason they get exemptions from or benefits of taxes and etc. Because they are discharging duties of the state. Therefore, the state is ultimately has to ensure that whoever discharging duties in the private school get the similar benefits. So far this recruitment is concerned. And for that state is always can issue appropriate notifications and executive orders. Because these duties are fundamental to the state. One more thing, UGC regulation of 2018. So so far UGC regulation is concerned, this is in fact the latest regulation of the UGC. Now, compared to this regulation also, clause 10.
Hand over soft copies, you say what you are relying upon?
Clause 10 of the UGC regulation which prescribes the minimum qualification. Clause 10 G, it says no distinction shall be made with reference to the nature of management of the institution where previous service was rendered within bracket private, local body, government while counting the past service under this clause. They were not for the purpose of recruitment under that regulation. It does not make any distinction where I'm serving. I was serving previously.
Why did you file the writ petition at such delayed point of time?
Because there was no clarity. Only when commission has come forward with a rather evaluation kindly takes a yes, page 95.
Yes.
Since there was no clarity in the rules or in the advertisement, we have made representation to the authority since September, and none of this representation has been replied with. In fact, deemed to have been accepted by the commission. Commission could have replied me saying that no, you are not entitled to, in view of this provision.
Yes.
Therefore, there is no delay. We have applied disclosing our past experience. There was confusion. In fact, there are, your Lordship has gone through a few cases, must have that people were confused, they did not add their qualification in the form, or subsequently by virtue of course order, they have got the benefit.
Benefit granted to one Navodaya school and then again taken away.
In fact, what I'm trying to submit that there was confusion. There was lack of clarity. That is there. The state was supposed to come forward with all clarity. Oh, madam, দেখিয়েছি এটা কি সিমিলার জাজমেন্ট দেখিয়েছি দেখি দাও ওটা আমার নেওয়া আছে এই তো this is a judgment of Supreme Court. This was yet to be reported possibly, or reported in Supreme Court's website 2024 INSC 911 Monica and others.
Monica.
Chaudhary Charan Singh, Haryana Agriculture University versus Monica.
24 INSC page
24 INSC page 911.
Chaudhary Charan Singh.
Yes, my lord.
Yes.
In fact, this judgment ultimately decides that merit should prevail. I hand over a copy.
You read out.
A literal reading of the terms relating to experience confirms that marks could be secured by an aspirant for experience gathered while working in the enumerated department of the government of Haryana. However, while referring to the same or to a higher post, the term sanctioned as a prefix is conspicuous by its absence. Additionally, neither the outsourcing policy nor the advertisement defines the what post. What follows is that an aspirant to secure marks for experience must prove with documents that she has been employed for performing work of the nature required by the same or a higher post. Importantly, it has not since shown that either recruitment rules or the advertisement specifically bars aspirants from securing marks for experience sent from contractual outsourced employment. Thus, we have no hesitation to hold that the mode of employment is not the primary concern. To our mind, the primary concern is the nature of work performed and whether the work undertaken by the candidate has any nexus with the purported work to be undertaken during the course of regular service. that the first respondent had rendered service for a statutory body in excess of 6 months and is therefore covered by the last part of clause D does not admit of any doubt, and hence she had a valid claim of securing 0.5 marks for experience. The state policy specifying that the individual must have worked on a post equal to or higher than the advertised post in any of the enumerated departments to secure marks for experience also reflects the state's belief that the experience in such department is directly relevant to the advertised post. It is not open for the university to now deny marks on the basis of a technical procedure deviation that the experience certificate was not issued by the university but rather by the service provider. While we accept the contention raised by the university that the certificate was per se not issued by it, the fact that it was countersigned by the head of the department validates the first respondent's claim that she had indeed gained certain experience which deserved to be given credit. We also do not agree with the contention of the university that the first respondent did not work on the post of clerk, rather performed office work. The certificate awarded to her evidently mentions that the work she has required to undertake is work of clerk cum typist. Moreover, certificate also mentions that her work was found quite satisfactory. The first respondent has also brought on record a memo by the professor and the head of the department which specifically acknowledges that she has been designated as clerk cum typist during her tenure. Then 26. The true thrust of every selection process ought to be, this is the ratio of the judgment, ought to find out that the select suitable candidates having experience in the related work and fulfilling other criteria. An individual without having any security of service performs up to the mark and receives commendation from none other than the head of the department, who must have closely watched her performance. It would occasion a failure of justice to exclude such individual for no better reason than that she did not work on a sanctioned post. If indeed such be the requirement, it had to be made explicitly clear in the advertisement without any ambiguity, so as not to generate false hope in the mind of the individual aspiring for public employment. Any other view would be against both the principles of equality and non-arbitrariness enshrined in the Constitution, as well as the principles of natural justice tested on the touchstone of Article 14 and 16. The impugned decision of the university cannot sustain. It covers both. One, not the merit, you cannot ignore private institution, and third, the benefit of experience to the candidates participating in secondary high secondary education post. The experience up to 9-10 is being taken into consideration. But all these 4 points is being covered by this judgment. I'll hand over the reported copy. This is all.
All right. Yes.
No, not 4, 5 points are covered by the judgment. That mark for prior experience can be given. That's also been covered by this. But I'll come to that.
Without any
The paragraph read by Mr. Ahmed distinguishes itself. Anyway, but kindly takes the 1997 Act once, from which Mr. Ahmed started. Well, my argument might seem repetitive because this question fell from your lordship that your lordship, I have already disclosed the nexus, but kindly comes to the Act. Kindly take section 17 2D.
Two D.
17 2D, 17.2 I am reading, but 17 I am reading, the state government may by notification make rules for carrying out the purposes of this act.
In particular, and without prejudice to the generality of the foregoing power, such rules may provide for all or any of the following matters. D being the manner and scope of selection of persons for appointment to the post of teachers under subsection 1 of section 8. Therefore, my lord, I can make rules. I have the power to make rules, my lord, formulating the manner and scope of selection of the persons for appointment. Then kindly comes to 8.1. 8 subsection 1, manner and scope of selection of person and procedure for the conduct of business of the commission. The manner and scope of selection of persons appointed to the post of teachers shall be such as may be prescribed. Therefore, the power of selection and to lay down the rules at the manner and scope how the teachers will be engaged is bestowed upon the state. Now, my lord, the definitions which has been read out, the definition of school and definition of teacher, nowhere mandates the state that the private teachers of private schools must be included in that foray of selection. What it merely defines is what school will mean within the meaning of this act and what teachers will mean in the scope of within the scope of this act. Therefore, there is no bar or embargo created upon the state that the private teachers cannot be left out while making selection to the post of teachers under the definition of 2P. If my rules are within the scope of the parent act and if there is no express bar upon me, then my rules cannot be challenged by showing two definitions which in no way creates any embargo upon me to leave out someone. Whereas, on the contrary, section 17 read with section 8 gives me the power to set forth what criteria I will have to appoint the teachers as required under this act. Now, my lord, to support the contention, my learned friend has relied on the NCT Act. Now, my lord, the definition of NCT, the definition of school in section 2KA of the NCT Act of 1993. Now, my lord, this definition of school in the NCT Act has to be understood in the context of the NCT Act. Well, before, my lord, coming into force of the NCT Act, the NCT merely had advisory jurisdiction. The intent of bringing in the NCT Act, and I'm reading, my lord, from the statement of objects of that act, that the present bill, I'm reading point number 3 of the statement of objects and reasons. The present bill seeks to provide statutory power to the NCTE with the objective of determination, maintenance, and coordination of standards in the teaching education, laying down norms and guidelines for various courses, promotion of innovation in the field, and establishment of a suitable system of continuing education of teachers, not education of students. Then number 4. The bill seeks to empower the council to make qualitative improvement in the system of teacher education by phasing out substandard institutions and courses for teacher education. The NCTE would be empowered to grant recognition to institutions for teacher education and permission of recognized institutions for new course for training in teacher education. Then, my lord, the object of the act. The object of the act is to achieve planned and coordinated development of the teacher education system and also regulation and proper maintenance of norms and standards therein. St. John so-and-so, 2 judgments of the Supreme Court has been referred to. Now, my learned friend is reading the definition of school under section 2KA in isolation. The definition of school under 2KA has to be read in the context of section 2L, which is teacher education, and 2M, which is teacher education qualification. 2L is teacher education, means programs of education, research, or training of persons for equipping them to teach at pre-primary, primary, secondary, and senior secondary stages in schools and includes non-formal education, part-time education, adult education, and correspondence education. And 2M is teacher education qualification, means a degree, diploma, or certificate in teacher education awarded by a university or examining body in accordance with the provisions of this act. Therefore, when the NCT Act defines school, it defines schools in relation to teacher education, not appointment of teachers in schools as my lord required under the purpose of the rules of 2025. Therefore, that definition cannot be relied upon to say that since the definition of schools there does not leave out private schools, therefore the schedule 2 of the rules of 2025 cannot be only restricted to government and government aided schools. But similar is the argument for the RTE Act. For the RTE Act, the purpose of the Act is to be seen, and the definition in the RTE Act will also have to be read in the context of the RTE Act. The object of the RTE Act again is to provide free and compulsory education to all children of the age of 6 to 14. But it is no way the definitions contained therein, unless it's a case where one definition is not present in my Parent Act of 1997 and we need an aid from another similar act. But my specific case being there is no embargo under the 1997 Act to put in this criteria where some teachers are being restricted. Now, that is the power. Now, then comes the rational nexus, which I have already submitted in the earlier matter. As far as the government and the government aided schools are concerned, the procedural verification is much more easier. As far as private schools are concerned, obtaining a certificate and coming and then again a bunch of litigation saying that that person did not have experience, that experience was manufactured, etc. That this entire chapter, we do not want to go into. Now, this what the petitioners are submitting, that they are at par. Now, your lordship knows, a minimum of difference, in two cadres, minimum of difference in two jobs will make them unequals. Their mode of recruitment, their daily workload, their discharge of service, they are not at par with that of the government and government aided services. How the management of the private school will manage the teachers is different from that of the government and the government aided schools. But even I have named 3 criteria. But even if one criteria is different, they cannot be treated to be at par. That was the rationale under which we have proceeded from the beginning in framing of the rules. Now, all these teachers have applied knowing fully well that was what the rules prescribed. Now, if your lordship takes one of the representations as an example, what was their contention contemporaneously before as an afterthought these writ petitions were filed? Kindly takes page 95. Kindly towards the middle, kindly takes the sentence starting from Kintu Ami. কিন্তু আমি আবার আমার নবম দশম ও একাদশ দ্বাদশ ফর্ম পূরণ সময় দেখলাম যে আপনাদের ওয়েবসাইটে প্রথম ক্লিক করতে হচ্ছে গভর্নমেন্ট এডেড স্পন্সর স্কুল কিনা, তাই ভাইস কোড মারলে আমার স্কুলের নাম সেখানে দেখা যাচ্ছে, তাই ভুল তথ্য হয়ে যেতে পারে এমন আশঙ্কা করে বা নিজের ভুলবশত আমি ওই সময় আমার অভিজ্ঞতা সংক্রান্ত তথ্য নথিভুক্ত করতে পারিনি. When they are saying this, 18th of September 2025, when the last date of form fill up was in July. So, in July, as an afterthought, they suddenly realized that why private schools should not be included there. When they know that by way of the Honorable Supreme Court's direction, the entire recruitment process is being proceeded. And even in the last order, your lordship has seen that the Honorable Court has recorded one line that the reason for pendency of these SLPs were to see that in terms of our directions, whether recruitment process is proceeding or not. Therefore, for throwing a spanner in the wheels, suddenly they come up, and similar cyclostyle representations are there in 97 onward, 97, 99, all similar language, verbatim reproduction. Therefore, now I come to the judgment cited by my learned friend, which in paragraph 26 distinguishes itself. In that case, the rules did not clearly bar the person who intended to participate. আমারটাই বন্ধ হয়ে গেল। তোমার যেটা প্রিন্ট আউট আছে না, আমার নেটটা ওটা বন্ধ হয়ে গেল। Malad, in that case, Malad, the person had already worked in the same institution under the same university in the earlier round as an outsourced manpower. As an outsourced manpower, the same person was there, but the rules did not clearly say that he will be debarred. Therefore, Malad, I'll just read out Malad paragraph 26 once. The true thrust of every selection process ought to be to find out and select suitable candidates having experience in the related work and fulfilling other criteria from amongst eligible candidates, and to go ahead with appointing the more meritorious of those found suitable. If indeed an individual without having any security of service performs up to the mark and receives commendation from none other than the head of the department, who must have closely watched his or her performance, it would occasion a failure of justice to exclude such individual for no better reason than that he or she did not work on a sanctioned post. I'll just pause here for a moment, then I'll come to the next part of it. So, Malad, the head of the institution there certified the working. Malad, this is exactly where we are. Here, we are not the employer as far as the private teachers are concerned. Teachers in private schools are concerned. Therefore, we do not have this mode of verifying and certifying as an employer that yes, this person has discharged the duties and this person has the prior teaching experience. Then coming to the next part of it. If indeed such be the requirement, it had to be made explicitly clear in the advertisement without any ambiguity, so as not to generate false hopes in the minds of individuals aspiring for public employment. Any other view would be against the principles of equality and non-arbitrariness enshrined in the Constitution, as well as principles of natural justice, meaning thereby, if you want to exclude someone in the process, you make it clear in the rules itself, in the advertisement itself, which is a fallout of the rules. So, Malad, paragraph 26 itself, Malad, gives credence to our mode, which we have adopted. We have made it specifically clear that these will be in the foray and these will not be in the foray. It may be open to interpretations that whether substantive means substantive or not, etc. But what we are willing to give, we are not saying that someone is debarred from participating, but we are saying that we will only recognize that prior teaching experience which is within the criteria that we have laid down, and which is beyond it, we will not give prior teaching experience. But I can go back to one of the arguments made by Mr. Dhar in the last week. But if the person is really meritorious, that person may still steal a march over the person having prior teaching experience. We are not debarring anyone, but where we will hear this word, more meritorious of those found suitable. But we have our definition of merit. We believe that person having prior teaching experience in the government and government-aided schools will be more meritorious. But the definition, the interpretation of merit may be open for all of us to argue. But we have made it clear that who is within it and who is outside it. Therefore, as far as this judgment is concerned, this is not in the aid of the petitioners. The relevant fact which I relied on in that judgment, that they were working as outsourced manpower, in that, your lordship will find that in paragraph 9 of that judgment. So paragraphs, I'm sorry, paragraph 6 of the judgment. Not 9, paragraph 6 of the judgment. Now, 6 Roman 4, the experience certificate was not issued by the university, but rather by Lavanya. Merely, Lavanya was the third-party agency which recruited the manpower. Merely because it was countersigned by the head of the department does not make it a certificate issued by the university. Attention was drawn to the circular dated so and so, which prohibits issuance of experience certificate by any authority where persons are engaged through a service provider that is under part 1 of the outsourcing policy. But it was the contention of the university that since the head of the institution has given it, it cannot be construed to be that of the university. Those are
will be more or less your submission. See, main issue as to whether
Challenge to the rules.
yes, that is still there. So even if you all have primarily made your submissions, I'll keep the writ petition pending.
With that of
yes,
we tagged with that matter.
with the rule matter. Otherwise, there may be difference in facts in little bit here and there
Submission I have made in addition to the submission
that you've made there. Because as and when clients come, little bit here and there is a difference. You add up grounds, you are seeing how the submissions are advanced, and then you develop yourself. Well, it's all right. Please come.
Only one more thing to add on. That is the factual matrix of the experiences they have. The mode of appointment letters they have disclosed. My lord will take up only page 48 once. That is the appointment letter given to the petitioner number 1, Muhammad Moniruzzaman.
Yes.
But here it says, I'm not reading the first paragraph. It says, your appointment is, however, purely temporary, but it may be continued on consideration of merit of your service. Substantive appointment will, however, be given after 2 years of continuous service in our school. Your salary is fixed as such and such per month. You are, however, entitled to get other allowances as per schedule. Then there are a few allowances mentioned. If Milords thereafter take up page 50.
Page 50.
50, Milord.
Yes.
Page 50 is the another school where Moniruzzaman has subsequently gone, Milord. That school is also recognized by the Board of Secondary Education. That here says he is appointed as an assistant teacher of social science group. And Milord, from paragraph 2 of the writ petition, it appears that Moniruzzaman is a, sorry, not paragraph 2, Milord, paragraph 1, Moniruzzaman has a MA BEd. So MA in, first of all, social science group, Milord, perhaps they are trying to refer to history, geography, civics.
Page 48 is history. Page 48.
Page 48 is history. It's a different school. It's a different school.
School is different, but the
Yes.
subject is history, and here it's
Then
social science.
Social science group.
History falls within the social science group.
Milord, I don't disagree, but the moment you are not specifying the person concerned, what responsibilities are being taught, Milord, the discussion and deliberations are that what are the differences between a private school and a government school. Milord, let's, for example, a government school for a substantive post, a selection process either by the under the act or through advertisement and other methods has to be adopted. Here, whether any advertisement is being made, whether there is a recruitment process followed, whether it is a backdoor entry, whether it is just because somebody knows someone, I'm not disregarding their service or their merit. But I'm just saying, Milord, the process is different. And if we go through, every letter will have a different meaning and a different outcome. There is no stable situation to say that a person concerned have been teaching in a particular post, in a particular methodology for a particular period, discharging similar or identical duties. Other pages have the same things. Milord will kindly take up page 51A. The appointment letter itself is does not disclose anything. It only says, congratulations, I am pleased to inform you about your teaching confirmation for the post of assistant teacher in history PG of our school such and such with effect from such and such. I congratulate you and welcome you on behalf of all teaching and administrative staff of such and such. Now you are the family member of Shishu Bihar such and such. I hope we will work together very hard to achieve the goal of our school.
How are these appointments made? By regular recruitment process, advertisements called for.
Must be. But I'll respond to that.
Mm.
But,
Next day.
College service, school service commission.
But ultimately, it's the responsibility of the state.
Okay. I did not like my argument. But
Yes.
Well, I'll respond subsequently later. To since your lordship is hearing all matters, I have prepared a chart. Kindly to this kindly see.
Where from are these tables coming? Are the figures there in the website of the commission? All right. All right.
Now kindly see left hand side Bengali fresh selected 0 out of 219. Then this Bengali general male female 0. Bengali general female 0. Bengali.
What does this 0 mean? Nobody qualified.
Nobody from freshers.
Oh, nobody from freshers qualified. All right.
Right hand side person who has experience.
You did not.
Total number is the person who are having experience. This is a total post. These are freshers. So general male female there is nobody from freshers. Female 0. OBC A 2. Ultimately I have in the bottom I have given the percentage. Only 4.12% out of 100. Now in every subject I have prepared this chart.
Prepare another chart
with names. With names.
No.
Otherwise, we don't know how to who these two are, who these 249. We do not know.
Is it there in your, No, is it there in your website? The names of the candidates are also there.
Number of
must be getting it.
No, freshers. Who is freshers and who is not freshers?
Is it there in your?
I have to ask.
Yes.
Because the experience number, they are inside.
Yeah, the OMR sheets, are they published?
Not yet.
Not a single one.
Today morning we took a modification.
Or in regard of 2025. Not only that, persons of today, although that's the last day. Within 8 months,
Yes.
that whole
But then I have added a rider that in case they do not publish, then you have been you will permit them to participate in the recruitment process.
In particular for they are not even allowed the candidate because today it's allowed that.
So far as the publication of OMRs is concerned, today morning only I sought leave. Has granted leave so that on 10th that modification application can be heard.
Because of that, they are not.
That is only publication. This I have.
No, this is different. This is different. He says that
were not allowed.
They are not being allowed to participate in the recruitment process. Today is the last date. Check up. What are the details? What are the details which are available in the commission's website? The seat vacancies certainly is there. How many candidates participated in the recruitment process? It is there. Freshers and the old ones, the experienced ones.
That I am not sure. I have to seek instruction.
No, but if they are
Prepare
producing
the
this
chart.
chart, they must be having the names of these persons.
Provided it is there in the website,
Sir, I have
not preparing it.
But if this data is there in the website, the printout of the data can be taken.
Yes, yes.
What has been given is a handwritten calculation.
Yes, yes.
So if they are, if it is so credible that it can be, no. If it is so credible that it can be handed over to the court,
Whatever. I
without
think
an
that's what
affidavit.
the commission says.
But let them disclose the names of these 2%, 2%, 7%, 6%, 4%, 4%.
Let them put this on evidence so that
Why will I multiply documents? You have your data. You can come up with your data.
have to compile. They have already
Please
done.
do, because this data will be required. It will be relevant. So you please.
How they have done it.
Don't rely upon what they have done. Because I will rely upon your data. Certainly not on the data upon the petitioners. Commission, it is your recruitment process. You will have the data as to the number of vacancies, the number of candidates who applied, and the freshers, the experienced ones, those who will get the prior teaching experience marks, how many of them qualified, and all these details data you keep on preparing, because I'll require this for the preparation of the judgment, right? So keep it with you. He has prepared somehow, where from some details must be there from where this has been prepared, but then whatever, I'll rely upon the data from you, not from any party.
Category wise, subject wise.
Yes, everything. Category wise, subject wise, and if you publish the OMR sheets, your workload will be reduced. The matters before the court can be reduced.
We have no reason not to publish.
Yes.
But there is a few technical difficulties.
Please fix it.
It is.
They're in the application. We'll place the application.
Yes, we will have to place the application. Let that be reserved for Mr. Bandopadhyay to assist the court.
All right, but then try to fix up the technical difficulties which you all have, so that the matters don't reach the court's table. The thing is this, you should do it in such a transparent manner that the court is not burdened. See, the day from the after I got this determination, the second SLST matters are filled up, and the other matters, in fact, pension matters, compassionate appointment, urgent matters are being held up. So if you take care of this, then a lot of matters can be taken care of.
Information, I will.
Yes, the data. And I'll hear your reply.
His benefit, then everybody will benefit.
What benefit?
No, এটা কোনো কথাই হলো না।
That
এটা
is
বোকা বোকা কথা।
that is something else.
This is my judgment. I have relied on that.
তুমি যেন ফ্রিতে মামলা করে ফাটিয়ে দিচ্ছ এমন করে কথা।
What judgment is this?
Judgment that I have relied on that.
মক্কেলরা পয়সা দিয়ে দিয়ে পাগল হয়ে যাচ্ছে।
Oh, Monica. All right. Which paragraph did you mention?
I have relied on paragraph 23 onwards.
23 onwards.
22 onwards. 22, 23, 24.
Mr. Bandopadhyay relied on paragraph 6,
26.
Roman 4 and 26.
And that amendment to the NCT Act, which was introduced in 2012, in the preamble, it includes including qualification of school teachers. That was included in 2012.
NCT.
NCT.
Right. I'll hear you. All right.
The relevant act,
NCT?
NCT Act.
Had submission made on behalf of the petitioner and the respondents. Stop. The petitioner would be entitled to give reply on the next date. Some of the matters are fixed on the 22nd or 23rd. Any matter is fixed 22nd, 23rd.
Vocational teachers matter.
First,
Vocational teachers matter.
upper primary.
Vocational teachers matters is there. No, they're not on that date.
I'll be requesting you, Lordship, last occasion I made this submission. In other matter where rules has been challenged, that they should produce the file to disclose the reasons for introduction of new rules, while 19 rules has never been.
This is going beyond
what the matter we are discussing
Thing is, in the last occasion, Mr. Dhar took the responsibility of preparing a comparative chart between the 16 and the 2025 rules.
Comrade,
And then the AG also will make his submission as to what was the requirement of bringing in this new rule.
My submission was this is not between 16 and 25. Because after 16, between this period, there were 19
came.
rules.
Yes, the AG has submitted. He'll make submission. And then a comparative chart will certainly come. You all also prepared. Nobody is stopping you. Come up with a chart. 16, 19, 25.
But the reasons must be with them. So they can apprise the court.
Yes. But then what you can see that this is the difference. That you can always point out. This was there in 16, not there in 25. Was there in 19, not there in 25. This
I'll prepare a list. I'll prepare a chart, but last occasion my submission was the 19 rules was more transparent and more based on merit rather than experience.
Whatever. Let the AG submit. Thereafter,
I'll respond.
We will see. Maybe the state can also come up with a comparative chart as to what was the requirement of this new rule and not the old one. Let the state make submission, then I'll see. This week, possibly whoever are there for the petitioners and everybody will finish up, and then I'll start with the respondent state and everybody is there. Keep it on 22nd. Let us see what happens.
One line order is required that since the lordship is hearing this all rules challenge matter together, kindly mark it as part hard nuts. Since long we are arguing.
Mention from the
they have
second half. Suddenly, I do not know that we do not know. We do not know really.
Everybody has spent time,
Judicial hour has been spent.
Yes, that's the reason. So one line is required.
No, doesn't matter. We have heard, we are recording orders. The court is aware that the matter is being heard.
Next matter is probably same.
28.
Same or not same?
No.
Same no.
Private teachers.
Private
unaided school recognized, approved. But my learned friend, here my learned friend's submission. My learned friend's submission would be tenable before 2011, not after 2007. Why I say so, my lord? First, my lord, I start from advertisement.
Teachers of unaided government
schools.
Government sponsored school.
No, my lord. This is, my lord, unaided, recognized, approved, unaided school, my lord. They are the teacher, experienced teacher, and all the teachers have experience. My lord, kindly just take one of this approved by the West Bengal Board of Secondary.
Ahmed that brought this book.
It's from the Bar Association. It has to be returned. Any of his juniors will collect the book. এখানে আছে
এই বইটা নিয়ে যা
ঠিক আছে মানে kindly turn page number 53. Why their submission is not tenable? It is evident from their advertisement itself. Kindly turn page number 53.
Yes, please.
Nota bene, the eligibility criteria is mentioned.
Yes.
My lord, education and qualification, including professional qualification for selection of assistant teacher for class 9-10 in school. Nota bene, 2. The minimum qualification as prescribed by the NCT attained on or before the last date of receiving of online application and mentioned in the application form shall only be considered for academic and professional qualification. So it is evident they follow the NCT and they ought to follow. Why? My lord, NCT Act, because my lord is well aware that fact that, my lord, and this is a constitutional position. Education is a concurrent list subject. Concurrent list, Schedule 7. List 3, entry 25. And that is if they so they will not give experience number, it is directly repugnant to the central legislation. Entry 3, list 3, entry 25. education, including technical education, medical education, and universities subject to the provision of NT 63, 64, 65, 66 of list 1, vocational and technical training of labor. So education is a concurrently subject. State as well as central both can make the rule. If that is direct conflict, then central will prevail. Now, my lord, kindly take the NCT Act. First, my lord, I place the legislative intention. পুরাতন branch কথা NCT branch. My lord, in this branch, my lord, that was earlier act before amendment.
No, the act is here. You want this bunch to be kept here? If this act is here,
My lord, because of that, 3 bunch was there already. 2 bunch already handed over
keep
to
it with you. Do not give me bunch. Take it.
already. My lord, court room number 14. Another
It doesn't matter.
primary. So, my lord, before amendment, there was no such inclusion. I just after amendment, an act to provide for establishment of National Council for Teacher Education with view to achieving planned and coordinated development of the teacher education system throughout the country, the regulation and proper maintenance of norms and standard in the teacher education system. Now, my lord, this entered in the year 2011. Why entered, my lord? What was the legislative intention? I will place later on. Including qualification of school teachers and for matter connected therewith. And it is inserted in the year by Act of 18 of 2011. So in the year 2011, it is, my lord, inserted. Now, my lord, kindly take the school definition. That is 2KA.
Yes.
School means any recognized school imparting pre-primary, primary, upper primary, now in our category, secondary or senior secondary. That means 9, 10 and 11, 12. Or college imparting senior secondary education and includes a school established, owned and controlled by the central government or the state government or local authority. A school receiving aid or grant to meet whole or part of its expenses from the central government or state government or local authority. That means a dear getting type of school. 3, that is important, which we fall in that category. A school not receiving any aid or grant to meet whole or part of its expenses from the central government, the state government, or any local authority. We fall in that category. Now, Malat, kindly take section 12A. Section 12A. Capital A. Capital amendment in the year 2000. And this amendment came in the year 2011. Why this amendment came, I will explain, my lord, by showing the Right to Education Act. 12 capital A. Power of council to determine minimum standard of education of school teacher. For the purpose of maintaining standard of education in school, the council may, by regulation, determine the qualification of person for being recruited as teacher in any pre-primary, primary, upper primary, secondary, senior secondary, or intermediate school or college by whatever name called, established, run, aided, or recognized by the central government or state government or local authority or other authority. So any school, provided that nothing in this section shall adversely affect the continuance of any person recruited in any primary, pre-primary, pre-primary, primary, upper primary, secondary, senior secondary, intermediate school, or colleges under any rule, regulation, or order made by the central government or state government, a local or other authority, immediately before the commencement of the National Council for Teacher Education Act 2011, solely on the ground of non-fulfillment of the qualification as may be specified by the council, provided further that minimum qualification of a teacher referred to in the first proviso shall be acquired within the period specified in this act and or under the Right of Children to Free and Compulsory Education Act 2009. Malad is well aware of the fact that Right to Education Act came into force after the constitutional amendment, Article 21A, in the year 2010, my lord. On that score, my lord, in the Act itself, Right to Education Act itself, my lord, there was a 5-year relaxation for those category, that is up to class 8, from class 1 to class 8, 6 years to 14 years student, children, my lord. But no other category, there was no such relaxation. Not only that, my lord, on that score, NCT passed a regulation in the year 2014, my lord. I just handed over, my lord, that regulation, which shows the what would be the minimum eligibility criteria to be appointed in a school, whatever. Maybe school might be run by the central government, might be run by the state government, might be run by any other authority, it might be aided, it might be unaided. What is the basic purpose of this minimum eligibility criteria? Standard of education. Bring the standardization of education. The NCT being academic authority, because in pursuance of the Right to Education Act, Section 23, central government appoint NCT as a academic authority in the year 2010. All these amendment came thereafter. Earlier, NCT Act was only for teachers training institute. Later on, in pursuance of the central government appointment as the academic authority, NCT appointed as an academic authority, they bring this to standardization of education or from preschool level to higher secondary level. Any school, might be unaided school. Every teacher ought to be a minimum eligibility criteria. Until and unless they have so, they will not get approval. Not by any authority, might be central authority, might be state authority, whosoever. So it is evident from this regulation as well as the act that every teacher, they have minimum eligibility criteria. And not only that, it is acknowledged by the advertisement. They follow the NCT. NCT says every teacher ought to be a minimum eligibility criteria, otherwise they will not be appointed as a teacher. So we, the unaided school teacher, have the minimum eligibility criteria. We have the experience, but they create an embargo upon us. Although that is not so clear. But kindly take the rules.
It is already 4:30, past 4:30.
I was just not putting him from behind.
4:33.
My lord, kindly, because I will do some provision.
তাহলে 22 তারিখে
Any-
করো, 22 তারিখে অন্য মামলা,
কবে রাখি?
22 তারিখে অন্য মামলাটার সঙ্গে করো। 22 তারিখে অন্য মামলাটা রেখেছে তো।
My lord, I have some another matter.
There are other SLST matters I can see in the list.
Well, a similar matter your lordship has kept on 22nd December, my learned.
No, this one I understand similar, but the rest I do not know.
Rest again, we'll come back to it tomorrow.
Right, because it's absolutely impossible.
কি
Petitioner,
আরে এগুলো বললে আরেকটা পিটিশন কালকে ফাইল করে দেবো অন্য লোককে নিয়ে।
Why?
describe where he is working.
That is all are annexed, all are annexed.
First it has to be pleaded, then annexed.
All are annexed, my lord.
Paragraph 3 kindly.
Not only paragraph 3 is not ever only paragraph. My lord,
তো পিটিশন নিয়ে নিলি?
no.
কোথায় গেল?
Yes, class.
Yes.
সব পিটিশনে থাকে।
That is common paragraph.
কপি পেস্ট।
That is common paragraph.
Paragraph 4 is
Paragraph number 4. Paragraph
Schools. He says unaided in his submission.
unaided.
Unaided schools.
In different recognized unaided schools.
Unaided.
Schools
Second
in
paragraph.
West Bengal. 4 second.
Teachers in different recognized.
Unaided.
ওটা unaided হবে।
না, unaided করা আছে।
কোথায় unaided করা আছে? ভাই এটা inaided লেখা আছে। In that.
তার আগের লাইনে, তার আগের
Whatever. I am not. Let us understand. Unaided.
তার আগের লাইনে, 2 লাইন আগেই দেখো।
কোন স্কুলের নাম দেওয়া আছে?
The petitioners
এই ওগুলো এফিডেভিটে লিখবি।
claim to be teachers in recognized unaided schools.
কপি পেস্ট করতে গিয়ে সব গন্ডগোল করে ফেলেছে।
They participated in the second SLST within bracket 80. Examination
32 তো এখন হচ্ছে না, 32 রিপোর্ট দেবো কেন তোমাকে?
5 stuff. They seek marks
28 ছাড়া এখন কোনো
prior
হবে না।
teaching experience. Stop. Is the rules under challenge here? The recruitment rules, 2025 is pursuant to which the recruitment process is being conducted is impugned herein. Stop. Similar matters are being heard by this bench. Stop. Let this matter be tagged along with the said matters. Stop.
It's tomorrow.
It will be tagged that way, but then it is listed on the
2nd December.
22nd of December.
Second December.
অন্য মামলাটাও করে রেখেছে
The previous matter was also fixed on the 22nd.
Because of that matter, first ballot, adjudicate that matter whether 10 marks will be intravirus or ultravirus. Thereafter, this sorts of
Yes,
that would be
that
more,
is the idea. That is the reason I am hearing that matter first, and then everything comes
because
later
there
on.
are various layered, my lord. Unaided, contractual, part-time teacher, part-time teacher,
Central government,
all are there.
different state. There are variety of
matter regarding getting 10 marks, my lord.
right.
If that is,
my lord, we have learned from my learned friend. He really knows the variety.
You all are also learning. The court is also learning.
That in one thing say 10 marks not required.
As and when clients come to him, you appear for the petitioners. It's not that you do not know. So as and when whoever comes to you, speak for that person.
Mr. Sengupta's language.
Absolutely.
Approach করেছে.
Mercenaries.
May I mention one matter? Item number 35.
Title.
Challenging the lease. 3512 lease. Versus 6 square challenge. List of 25.
What is there to challenge?
This is the last date for filing of the application.
What is the challenge? If your name is there in the tainted list, you are there.
Falling under the category of 25.
Which category you fall?
Direction.
Which category you fall?
Not the falling under the three categories. Which are
Three means which one? Which item are you mentioning?
35.
I'm led by Mr. Anindo Lahiri.
Where is he?
Arnob Mukherjee was taken up.
Yes, yes.
Going to be at 495 writ petitioners without stamp.
All right.
On the stamp issue, it was adjourned last Friday.
Right.
Submitted the
Yes. So make submission. Make submission. You call him at 4:38. You should have been here.
Item number.
I cannot help. Yes, please.
Item number 32 is the last occasion there is a direction to file the report miscalculation because of verification is going on.
No, already over. 4 তারিখে over হয়ে গেছে।
Verification
marks.
One marks will be added if they properly calculated.
Right.
So that matter is item number 32. If they bring it tomorrow ballot, that will be one minute matter. That will be miscalculation, nothing else. And second
এটাকে রাখুন। এটা 22 তারিখ হয়ে গেল। Take back your book.
and my lord, item number 22.
One minute, one at a time. 32, you said 1 mark. 32, 1 mark.
Yes, yes.
Who's there? Commission. 32, Mr. Bhattacharya, what?
It can be seen from the petition itself. My learned seniors are there. We can show it from the petition, read petition itself.
What?
There is no They have calculated their marks on the basis of preliminary answer key, not on the basis of final answer key. In the final answer key,
Mr. Singh is poised with the facts. Better me not let him argue.
They have
had to be mentioned.
To be mentioned, not possible. Wait, 32 is going on. দেখি একটু 32 টা If you say the calculation is
it can be shown
erroneous,
from the petition itself, Milord.
order তোকে দিন
Order তো জজের হয়, তোমার কি করে হবে?
which page?
Milord, they have
It
made
is
a
not to be
tabular
marked
chart.
1 mark more 54.
They have made a tabular chart at page number 50, Milord.
50,
It is
yes.
made by the petitioners only. It is written on
Right.
the top. Milord, the
Yes.
tabular chart, Milord, is made from preliminary answer key. Milord, kindly see page number 51, question number 47.
Yes.
According to them, the correct answer should be D, and they have marked it as D. Milord, now kindly takes Milord the final answer key, which is at page number 45.
Yes.
My lord, their booklet code is code number C. My lord, have your lordship not got it? My lord, page number 45. My lord, kindly see under the booklet code C, question number 47 is the fourth column.
Yes.
My lord, the answer, final answer is B and C. They have
47.
prepared a
Question number 47 in the fourth column. 1, 2, 3, 4.
Lord, master is fourth. In C series, it is question number 47, Lord.
C series, question number 47. B and C, yes.
B and C. Lord, this is the final answer key. Lord, kindly take the next page.
Yes.
Lord, the next page is the page number 46. This is the preliminary answer key which was published by the commission. The fourth question is a master question, which is C.
Petitioner
That
has
was
marked
D.
it as A.
D, my lord.
D. And you first your answer was A, then it comes to B and C. Except D, you have marked all correct.
First, my lord, it was D. Then, my lord, it came to B and C.
We'll see later on. Different final answer is differing.
Yeah.
Yes, 33.
Item 30.
So what has happened?
Regarding that, my lord, the Sanskrit subject, model answer key and question. 1 mark he's missing out to become qualified. They were supposed to give a report. Yes, tomorrow, let it appear tomorrow, my lord.
It is there in the list.
Very well, let me be taken up.
30%, my lord.